Read that again.
Solomon Knighton with his shirt off was yelling and pounding at the door, trying to be let into the home. Knighton was screaming and calling the victim a bitch in the footage. Knighton can additionally be seen kicking a chair off Brown's porch before leaving the area.
Is that what happened?
Yes, sir.
It's a little different than knocking on the door, isn't it?
Yes.
Guilty plea is accepted. They're refrain from having contact. Why is he doing this?
Judge, it's the
I mean, it's two wrongs don't make a right, okay? He doesn't get to come in here and defend his actions and then say, well, she went over there and she committed a malicious destruction of property. Nobody heard me say I'm condoning her conduct, but I'm certainly not, if that happened, I'm certainly not condoning his though. So what do you want to say?
So, Your Honor, it's really about these kids. And these cases are very tough when the two individuals have children together. And they live in very close proximity. They live in an apartment complex on either side of each other. Mr. Knight's mother is here. She's just gonna move him at this point because this is not, they're gonna continue to be in sport. Mr. Solomon is trying to move forward. He's in school. He's supposed to be in school right now. He's going to Universal Technical Institute in Canton. He's helping raise his children. His mom gets the children. He'll keep the children. He's trying to get a job. He lost his other job at GM because of all of this.
How'd you lose the job?
Because he got a child with himself or domestic violence.
She got admitted to a mental hospital, so I had to get the kids. And I was still on my 90-day probation. And then my last security job, she called up there and claimed that I beat on there and.
So it was a security job. I misspoke. It's a security job that he lost because of this situation. At this point, he needs to move. So I would ask that the court maybe order more days on the court work program or another anger management class. If he goes to jail, it was supposed to graduate in June of this year.
Did he do the 8-week thing?
Everything's completed, yeah.
Did everything.
Everything's completed. And he's set to be discharged coming up in June 18th. Everything is done, other than this original contract where he's been compliant. And I did talk to the victim as well. She did not want to be here for this day. She did not want to speak or say anything. Yes, our is application for a case with him as the victim as well. I agree again with House Counsel here that this is going to continue to be a problem with them just being in the same area as each other and having a child together.
No, you've had a history of domestic violence. So you had one taken under HIDA in 23. That's fine. But then you had another one dismissed, and then this conviction, and then you're violating the orders. You had another one dismissed in 94. It seems like there have been multiple charges. I'm not going to assume you did anything wrong because they dismissed the cases. But the bottom line is that you're violating orders here and you're going to get yourself into some deep trouble. And I mean, that's a little bit more than indirect contact. You tried to play this down, right? Said you knocked on the door. You did more than knocked on the door. Shirt off, yelling the B word. Pounding on the door. What do you think?
Honestly, Your Honor, I'm not sure at this point. Again, I think they're gonna continue to be an issue back and forth, you know, contact orders.
Well, I'm not gonna put up with this, okay? You're not gonna violate orders. As far as I know, there's no judge that ordered her not to have that gentleman there, correct? Correct?
Yes.
Okay. Then who are you to play judge and jury out there?
Just my kids.
Well,
Was just to respect on my kids. That's all.
when's he scheduled to come on?
June 18th of 2026, Your Honor.
Judge, the graduation is in 2026, he's supposed to graduate.
Graduate.
Yeah, he's at Universal Technical Institute in Canton.
You're to pay additional costs of 70. I'm extending probation by a month until July 18th. You're to pay additional probation fees of 20. You're to serve 2 days on the court work program and pay $70 for that. So your total here is 165 plus 2 days on the court work program. I'm gonna caution you. Do not have any more contact with her. Do we understand?
Yes.
I think the initial order says that he can have contact to effectuate visitation, does it not?
Yes, Your Honor.
Between his mother, effectuates the visitation.
Okay. Defendant. I can't read my own writing. Isn't that horrible? It says mother. Somewhere in there it says mother. What did I say?
So on our no contact order, I said, state that he's not to have contact with the victim except to exchange minor child. That's how it's worded for.
Oh, defendant permitted to have indirect contact through his mother to effectuate visitation with the minor children. Is that not what I told you?
This was originally Ms. Tessino's case, so I'm just taking it over from here. I can go ahead and update it, but it's hard to read on the order.
Defendant permitted to have indirect contact through his mother to effectuate visitation with minor children. Is that not how we were playing it before, Mr. Knighton?
Yes, we were.
Okay, well, that, I'm still gonna allow that, but no more of this. Can you pay the 165 now, or do you need time?
Um,
How much time? All right, you pay this by April the 8th. Okay? You need more time? We'll go on Zoom. I'll give you an extension. Best of luck. Thank you.
Thank you, Judge.
Do I have Gage Maximus Cartier here? Gage Maximus Cartier here. This was actually set for 10:30. Is this set for 10:30?
Yeah.
Yeah, so it's fine. I'm gonna pass that. Seacon. Jaspreet Singh Zekan. Seacon,
He's on Zoom, Judge. He's coming in right now.
this is 26W841410. Mr. Seacon, you have to start your video and tell me your name, please. Your name?
Yes, sir. My name is just Pressing Sekho.
Where are you at? You're not in a car, are you?
Yes, sir. I'm in a truck.
You're not driving, are you?
No, I'm not driving. I'm in a sleeper berth.
How much more, you would need time to pay, you were supposed to come in with the money by the 16th. Next time you have to do this on or before the due date. Mr. Martin, I'm gonna ask you not to smoke, please, sir. Mr. Seacon, how much time do you need?
Sir, actually, I am totally broke. Can you give me some relief if it is possible?
I mean, I'll give you more time to pay. How much time do you need? I can't do any better than this, really, sir.
Okay. Okay. Can you give me 1 month more?
I'll give you till April 30th. Okay? April 30th you
Okay.
pay by. Good luck to you. Thank you.
Thank you.
Is Pantal here? Brandon Ross Pantal? 24B147651. Your name?
Brandon Ross can talk.
All right. All right, I accepted your pleas to probation violations. Back on March the 3rd. I revoked your status, entered a conviction. And I believe you were represented by a lawyer that day, were you not?
Yes, Mr. Haynes.
Well, let's get Mr. Haynes in here. Did you talk to Mr. Haynes about this morning yet?
I asked him, he said you would, he told me to wait to talk to you first and then he talks to you.
All right, so I'm gonna revoke your status, enter the conviction, and then I'm gonna sentence you. So why don't you go talk to Mr. Haynes first, and then when you guys are done, when he's ready, I will call your case, okay? You're up to call it. Dion Tala Diawande Law, 25F243345A and B and C. And then 25B148445A. Your name, sir?
Yeah.
All right, so you will, you're here for a show cause on 345A. You owe 225. 345B, you owe 213. On 345C, you owe 327, it looks like, or is that down to 127?
127 is the balance on that one.
127, and then you owe 340 on, you're driving on a suspended that was reduced to no ops. You have the right to a lawyer. If you plead guilty on the civil infractions, you could get 1 day for every $10 owed. So you could get 23 days on file A. You could get 22 days on file B. You all right? I know it's hot in here.
No, I'm around with a knock.
If you want to sit down, you can sit down. I don't want you to faint there. Go sit down at the table behind you.
Okay.
You sure?
Yeah, but
And on file C, you could get 13 days. And then on the misdemeanor, you could get 90 if I find you could have paid and failed to pay, and your failure to pay was not without your fault. So do you understand all of that?
yes,
All right. I'm gonna cut this short. You look like you're gonna faint.
okay.
Why don't you sit down? I'm gonna feel a lot better if you sit down behind you. You have the right to a lawyer. I'll be happy to provide you with one at public expense. You have the right to a hearing. At a hearing, you can question their witnesses, bring in your own, use the subpoena powers of the court to bring in those witnesses. You can testify or remain silent. If you remain silent, that silence would not be held against you. You understand all that?
Yes, sir.
If you plead guilty, you're giving up your right to a contested hearing of any kind. You understand that?
Yes, sir.
And you understand I said you have the right to an attorney. Would you like an attorney?
Yes, sir.
You work?
Yes, sir.
Where at?
Henry Ford, I just,
Nice and loud. I can't hear you. Henry Ford, what?
Henry Ford Hospital.
What do you do there?
For about,
You haven't been taking care of these at all, Mr. Law.
I was unemployed for a very long time, but I just got employed.
I mean, I'd like to give you another payment plan, but you've been playing around with this for a long time now. This has been going on for a year. Well, I know, but it has multiple times and I keep telling you, giving you more time. I'm gonna give you a lawyer. And we'll go from there. You gotta stop ignoring courts. Bad habit, really bad habit to get in. I'll go ahead and give you a lawyer and you'll meet with the lawyer and then you'll come back in here, okay?
Yeah.
Thank you.
That's, you know,
People against, Julian William Tom. 260-647-873.
He's on Zoom, Judge.
Did he meet with the department rep for, tracking?
He did.
All right, come on in here, sir. Your name, please?
Julian William Tom.
All right, so you met with the department rep and you are going to plead responsible to the charge of impeding, true?
Yes, Your Honor.
To that
Sure.
charge, responsible or not responsible?
Responsible.
All right, I'm gonna accept your plea. Your total's $155. You can pay that today, correct?
Yes, Your Honor.
You can go right on 33court.com with your case number and make your payment. You're all set. Best of
Thank
luck.
you, Your Honor. Thank you. Have a good day.
Andrew Lawyer Junior, 260-647-934. See here? Come on up to the podium, Mr. Lawyer, please. Could I also have seated at the table here, Ali El Hassani and Alec Johnson? Your name, sir?
Mark Lawyer.
You're going to plead to impeding traffic, correct?
Yes, sir.
And that's what you want to do?
Yes.
So that charge, responsible or not responsible?
Responsible.
Okay, I'll accept your plea. 150 is your total. The speeding's dismissed. Any questions?
No.
Okay, you can go right down the end of the hall, make your payment. You're all set. Thank you. Ali Abdullah Al Hassani, 260-647-961. And I'm gonna need Alec Johnson brought in. Are you Mr. Al Hassani? Come on up to the podium. Come on up to the podium, sir. All right, your name?
Alec Johnson.
Okay, so you are going to plead responsible to impeding traffic, true? You've got two other entries on here to that charge, responsible or not responsible. Plea is accepted. 165, cashier end of the hall to your right, and I'll dismiss the original charge of prohibited turn. Any questions?
Please.
How much can you pay today?
75.
All right, when can you pay the rest?
So.
Where do you work?
DoorDash.
I'll let you pay $50 bi-weekly. How's that? Beginning on April the 14th. If you need more time, you come in here on or before any one of those due dates. I'll be glad to give you an extension, okay? So 75 now and then 50 bi-weekly. Best of luck. Tatiana Lungo. 26F245-764. Good morning, ma'am. Your name? I'm sorry, say that again? All right, so. You gotta slow down, ma'am. Okay?
Trying.
They've got you pleading to 1 to 5 over and they're gonna dismiss the 45 and the 25. Is that what you want to do? That's one
Yes, sir.
point.
Yes.
To that charge, responsible or not responsible?
Responsible.
160 is your total. I'll accept your plea. You gotta slow down though. Your record's looking pretty bad here, okay?
Yes.
All right. 160 and you can go down the hall and take care of that. Good luck.
Thank you.
You're welcome. People against Kevin Robinson. Kevin Robinson, 26B149965. Good morning, sir. You're gonna plead to disregard a traffic control device causing an accident. Is that true?
Yes, sir.
There were 2 people injured in this. Is that right?
My understanding, yes.
All right, to that charge, this will be a traffic control device, or how do you plead, responsible or not responsible?
I guess, I'm pleading, sir.
Responsible.
I didn't see the light.
Responsible?
Yes, sir.
Okay, I'll accept your plea. 195, okay?
Yes, sir.
Right down the end of the hall, you can make your payment. Best of luck to you. Thank you. All right, people against Muhammad Asghar, 26B 150517. Whoever's got,
First phone has got to get out.
please, you gotta take the phones out, please. Thank you. There's signs all over the building. David Brush can come up to this table and have a seat here at my right, your left, and Nyquist can do the same. Your name, sir? This is Muhammad Cameron Asghar, 26B 150517. Your name? All right, so you are going to plead to impeding, right? You two have to be careful, okay? To that charge of impeding traffic, responsible or not responsible? I'm sorry? I'll accept the plea. 170 is your total. Please be careful out there, okay? Thank you. How much do you have today? 50? When can you pay the rest? I'm sorry?
End of the April.
End of April? Okay, no problem. April 30, okay? If you need more time, you call the court. We'll go on Zoom. I'll give you an extension. Best of luck to you. Do I have Tyler Nyquist here? He needs to have a seat at the table. David Brush, come on up here, 26B 150573. Your name, sir?
David Brush.
All right, good morning to you. You are going to plead to impeding traffic, correct?
Yes, Your Honor.
Responsible or not responsible to that? All right, 150 is your total. You got a clean record. I wish you well. 150. You're all set. Thank you. Tyler Nyquist, 26B 150574. Come on up to the podium, young man, please. Your name?
Tyler.
How you doing? What are you doing now? Are you in high school?
Yes.
Where at?
Courtroom Roulette.
What are you gonna do next year?
College. Well, I have to finish high school first.
Why not? Just relax. I mean, in the fall, what are you gonna do?
I go to Henry Ford Junior College because I'm going to take cybersecurity classes there.
Good. All right, so you're gonna plead to impeding. I'm not trying to make you nervous. I'll get you out of here, okay? For that charge of impeding, responsible or not responsible? Is your mom or dad here with you?
Yes.
Which one?
My mother.
That's nice to see. Thanks for coming, Mom. 150 is your total. Speed's dismissed. Slow down though, okay? You don't want to murder your good-looking face there. Good luck to you. Zachary Ostrowski, 26W841773. All right. Your name, sir? You're gonna plead the prohibited parking and they're gonna dismiss the expired plate, right?
Yes, sir.
Is that what you want to do?
Yes, sir.
All right, do you have? You have a valid registration now?
Yes, sir.
Okay, to that charge, prohibited parking, responsible or not responsible?
Responsible.
You didn't have a valid registration at the time of this though, correct?
At the time of the ticket, I did not have it resolved within the hour.
Good for you. You going to work?
Returning to work.
Where?
Romulus, fabrication plant.
All right, $85. You're out of here. Good luck.
Thank you, sir.
Have a good day.
You as well.
How about Scott Miller? 26B150229. Okay, it says both vehicles drivable, no accidents, no injuries, so charge is fair to stop a short clear distance. They're offering you impeding. Your name?
Scott Miller.
All right, just try to be careful, okay? To the charge of impeding, that's what you're gonna plead to?
Yes, sir.
Responsible or not responsible to that?
Responsible.
195 is your total, and you're all set and go down the hall and make your payment. Good luck.
Thank you. Have a good day.
You too, thank you. People against Trevor Gordon. Trevor Lynette Gordon, 26W841760. Got you going 42 and a 25. They wrote you for distracted. Your name?
Trevor Gordon.
And now you want an informal?
Yes, sir. That's right.
Okay, I just want you to know, I might let the officer, if he asks me to amend the citation back to speeding. He was trying to be a nice guy out there. He wrote you for distracted. He's got you going 42 and a 25, which by the way is a 4-point. So I don't have a problem with you telling me you want an informal, but I want to forewarn you, if he asks me to amend the citation to go back to the original charge, I'm going to do it. Do we understand one another?
Yeah, I don't believe I was going to class.
All you have to do is be going 26 and a 25, and that's 1 point. So I'm not quarreling with you. I'm just telling you, if he asks me to amend the citation, probably going to allow him to do it. He was being a nice guy out there. And these guys, when you start requesting hearings, that's fine. You have the right to a hearing, but I'm just telling you, I'm going to let him amend the citation if he asks me to do that. Do we understand that?
Yes, Sean, can I go back into
To the what?
to the citation that I was in?
To distracted?
Yes, sir.
I don't want to force you to do that. If you don't think you did anything wrong at all. But these guys are nice guys out there sometimes, and they give you a break on the road instead of writing you for what could have been a 4-point. He writes you for a 0-point that's not distractible. You do what you
Well, I
want.
don't have a point, sir. That was my whole
Well,
point.
you don't get any for distract. We don't even report it to the Secretary of State.
Understood.
So what do you want to do?
Take the strike.
You sure?
Yes, sir.
That charge of distracted driving, responsible or not responsible?
Responsible.
All right, I'm gonna accept your plea. Fines and costs are 155. I'll make it 150. You got a clean record. I'll cut that.
Keep it, sir.
Well, it is. Good luck. 150 is your total. You can go down the hall and take care of that and you're all set.
Thank you.
Best of luck. Antisic, Carol Sue. And I'm gonna need Alec Johnson. Julian William Tom. 260-647-873.
He's on Zoom, Judge.
Did he meet with the department rep for tracking?
He did.
All right, come on in here, sir. Your name, please.
Julian William Tom.
All right, so you met with the department rep and you are going to plead responsible to the charge of impeding, true?
Yes, Your Honor.
To that
Sure.
charge, responsible or not responsible?
Responsible.
All right, I'm gonna accept your plea. Your total's $155. You can pay that today, correct?
Yes, Your Honor.
You can go right on 33court.com with your case number and make your payment. You're all set. Best of luck.
Thank you, Your Honor. Thank you. Have a good day.
Mark Andrew Lawyer Jr., 260-647-934. See here?
With the
Come
podium.
on up to the podium, Mr. Lawyer, please. Could I also have seated at the table here, Ali El Hassani and Alec Johnson? Your name, sir?
Mark Lawyer.
You're going to plead to impeding traffic, correct?
Yes, sir.
And that's what you want to do?
Yes.
To that charge, responsible or not responsible?
Responsible.
Okay, I'll accept your plea. 150 is your total. The speeding's dismissed. Any questions?
No.
Okay, you can go right down the end of the hall, make your payment. You're all set. Thank you. Ali Abdullah Al Hassani, 260-647 961. And I'm gonna need Alec Johnson brought in. Are you Mr. Ellison? Come on up to the podium. Come on up to the podium, sir. All right, your name?
Alec Johnson.
Okay, so you are going to plead responsible to impeding traffic, true? You've got two other entries on here to that charge, responsible or not responsible. Plea is accepted, 165, cashier end of the hall to your right, and I'll dismiss the original charge of prohibited term. Any questions?
I feel payment plan better, please.
How much can you pay today?
75.
All right, when can you pay the rest?
So.
Where do you work?
DoorDash.
I'll let you pay $50 bi-weekly. How's that? Beginning on April the 14th. If you need more time, you come in here on or before any one of those due dates. I'll be glad to give you an extension, okay? So 75 now and then 50 bi-weekly. Best of luck. Tatiana Lungo. 26F2456764. Good morning, ma'am. Your name? I'm sorry, say that again? All right, so. You gotta slow down, ma'am. Okay? They've got you pleading the 1 to 5 over and they're gonna dismiss the 45 and the 25. Is that what you want to do? That's one point.
Yes.
To that charge, responsible or not responsible? 160 is your total. I'll accept your plea. You gotta slow down though. Your record's looking pretty bad here, okay?
Yes.
All right. 160 and you can go down home and take care of that. Good luck. You're welcome. People against Kevin Robinson. Kevin Robinson, 26B149965. Good morning, sir. You're going to plead to disregard a traffic control device causing an accident. Is that true?
Yes, sir.
There were 2 people injured in this. Is that right?
My understanding, yes.
All right. To that charge, this will be a traffic control device, or how do you plead responsible or not responsible?
I guess I'm good, sir.
Responsible.
I didn't see the light.
Responsible?
Yes, sir.
Okay, I'll accept your plea. 195, okay?
Yes, sir.
Right down the end of the hall, you can make your payment. Best of luck to you. Thank you. All right, people against Muhammad Asghar, 26B150517. Whoever's got,
First phone has got to get out.
please, you gotta take the phones out, please. Thank you. There's signs all over the building. David Brush can come up to this table and have a seat here at my right, your left, and Nyquist can do the same. Your name, sir? This is Muhammad Cameron Asghar, 26B150517. Your name? All right, so you are going to plead to impeding, right? You two have to be careful, okay? To that charge of impeding traffic, responsible or not responsible? I'm sorry? I'll accept the plea. 170 is your total. Please be careful out there, okay? Thank you. How much do you have today? 50? When can you pay the rest? I'm sorry?
End of the April.
End of April? Okay, no problem. April 30, okay? If you need more time, you call the fort. We'll go on Zoom. I'll give you an extension. Best of luck to you. Do I have Tyler Nyquist here? He needs to have a seat at the table. David Brush, come on up here, 26B150573. Your name, sir?
David Brush.
All right, good morning to you. You are going to plead to impeding traffic, correct?
Yes, Your Honor.
Responsible or not responsible for that? All right, 150 is your total. You got a clean record. I wish you well. 150. You're all set. Thank you. Tyler Nyquist, 26B150574. Come on up to the podium, young man, please. Your name?
Tyler.
How you doing? What are you doing now? Are you in high school?
Yes.
Where at?
Courtroom Roulette.
What are you gonna do next year?
college. Well, I have to finish high school first.
Why not? Just relax. I mean, in the fall, what are you gonna do?
I go to Henry Florida, college, because I'm going to take cybersecurity classes there.
Good. All right, so you're gonna plead to impeding. I'm not trying to make you nervous. I'll get you out of here, okay? So that charge of impeding, responsible or not responsible? Is your mom or dad here with you?
Yes.
Which one?
My mother.
That's nice to see. Thanks for coming, Mom. 150 is your total. Speed's dismissed. Slow down though, okay? You don't want it to marry your good-looking face there. Good luck to you. Zachary Ostrowski, 26W841773. All right. Your name, sir? You're gonna plead the prohibited parking and they're gonna dismiss the expired plate, right?
Yes, sir.
Is that what you want to do?
Yes, sir.
All right, do you have? You have a valid registration now?
Yes, sir.
Okay, to that charge, prohibited parking, responsible or not responsible?
Responsible.
You didn't have a valid registration at the time of this, though, correct?
At the time of the ticket, I did not had it resolved within the hour.
Good for you. You going to work?
Returning to work.
Where?
Romulus, fabrication plant.
All right, $85. You're out of here. Good luck.
Thank you, sir.
Have a good day.
You as well.
How about Scott Miller? 26B150229. Okay, it says both vehicles drivable, no accidents, no injuries, so. Charge is fair to stop a short clear distance. They're offering you impeding. Your name?
Scott Miller.
All right, just try to be careful, okay? To the charge of impeding, that's what you're gonna plead to?
Yes, sir.
Responsible or not responsible to that?
Responsible.
195 is your total, and you're all set and go down the hall and make your payment. Good luck.
Thank you. Have a good day.
You too, thank you. People against Trevor Gordon. Trevor Lynette Gordon, 26W841760. Got you going 42 and a 25. They wrote you for distracted. Your name?
Trevor Gordon.
And now you want an informal?
Yes, sir. Yes, ma'am.
Okay, I just want you to know, I might let the officer, if he asks me to amend the citation back to speeding. He was trying to be a nice guy out there. He wrote you for distracted. He's got you going.
That's Ms. Feltes and
We too agree that that seems like it might be a sign. We too would waive any conflict, although we do not think that there is a conflict.
The court, for its part, does not believe that a conflict exists either under Michigan court rules or the case cited thereunder. To the extent a conflict does exist, given the way which the court will consent to hear the matter. So, the court does call the case People State of Michigan versus Derek Williams.
And send on behalf of the people, Your Honor.
Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Williams.
Her name?
Derek Williams.
And your today the date time suffered preliminary examination. At this time, people are unable to see as to count one, but as for count two to be remanded down to district.
Your Honor, we would move to dismiss count one.
I'll continue the defendant's not guilty plea to count two. Pre-trial in this matter was set for
April 20th at 1 p.m.
April 20th, 2026, 1 p.m. That's before me. I didn't throw that in. Cool. Fine, we'll continue.
Your Honor.
German, Spanish interpreter. Which allows to use that. Just.
Why are we?
Burdell walked out too, so.
Jablowski and Burdell.
Yeah, they were.
Why were we adjourning?
Right.
Did you get that part? No,
No. I have so that you can review. I don't have the signed documents yet. He still needs to have her sign. I think he's planning on having her sign when she comes out.
is that Feltes?
It is.
Wow. Feltes. Long lost.
Morning, Your Honor.
I almost didn't recognize you.
The lovely woman to say is,
It is.
I know. Your Honor, he's on the record.
March.
Yeah.
But. But all March babies are great. Just wonderful people.
Technically, the only thing ready is this, and it's a holding exam. That's Ms. Feltes and Mr. Johnson.
Okay, but that's gonna take a minute, and I'm trying to,
You have 4 witnesses, Your Honor.
four, okay.
I don't know if that says anyone, please.
No, but he's gonna have a lot of questions, because that's what it does, but. There's a bunch of other things. What are we doing on those before everybody gets trapped behind that one?
I know that Mr. Kilowatts case, I can get. But he's talking.
He's what?
You
You want me to go get him?
You remember.
Oh, okay.
Yeah. So as soon as those guys on the wall. See what this is.
You're coming back, right? That's what we have to ask about. All right, see ya. It's gonna take my shots. Why don't we do?
You want to approach? Okay. We may here. I know, the comment is wonderful.
This is your phone wall.
Oh, sorry. Morning, Honor, Rob Fico on behalf of Zoria Brand. Would you state your name, Zoria? Zaria Brand.
The RCA didn't have separate preliminary examination. At this time, we are unable to proceed as to count 1 after count seems to be remanded down to district.
No objections, Your Honor.
Count 1 is dismissed. I'll continue to defendant's not guilty plea to count 2. Pre-trial in this matter will be set.
April 20th at 9 AM.
Set before Judge Washington.
Yes, before.
April 20th, 2026, 9 AM before Judge Washington.
Your Honor, may we address one thing? My client's wearing a feather, which originally I believe you ordered. Judge Washington, because of this case, confirmed that, but we're asking if you would consider removing a tether on her part.
Your Honor, I would object at this point. She is on probation out of 14B for a domestic violence charge, and we with the same victim. And I would think a tether in this case is at harm. Yeah.
I'm sorry? Well, it's still a DP, right? Okay. Your Honor, my client would agree to remain under house arrest. I just don't think a tether is necessary, Your Honor. We want to resolve these matters.
How would we know where she is? Yeah, that's what I thought. Motion denied. Bond will continue with it.
Thank you, Your Honor.
Court does call the case of the people versus Lakrita Thompson.
Well, Your Honor, I'll check loss with the people. Defender Bendel, on behalf of Ms. Thompson, who is joining me at the podium. Ms. Thompson, would you please state your name for the record?
Lakrita Thompson.
Can you say it loud enough so the judge can hear?
Lakrita Thompson.
I don't have
Your
a,
Honor, the defense had requested a no contest plea, or we'd ask for an adjournment to next week.
so why'd I read the report? I told everybody, send me the form, send me the report, and I take the no contest plea, even though I think it's untimely.
Thank you, Your Honor. Did you not get the plea form?
I don't have a plea form. I have the report. And was told what the plea was going to be. I don't know why I'd be adjourning if that's going to be the plea right now.
Okay, she is signing all the forms, and I can pass those to Mr. Allen right now with X's.
She's signing.
Thank you.
What is that? Oh, I see how they could. I have a plea form that indicates that she's going to be pleading to an added count 5 of operating while intoxicated second, the 1-year offense. Also, a count 6, attempted resisting and obstructing a 1-year offense. On her pleas, 2 counts 5 and 6 counts 1 through 4 would be dismissed. And that's the court's full understanding of the, is that correct?
Yes, Your Honor. Count 5 is not an added count, it's an original. Otherwise, that is absolutely correct. Thank you, Judge.
May I have her sworn?
Raise your right hand. Solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name, please.
Lakrita Thompson.
All right, ma'am, you understand that you'll be pleading guilty to, she's pleading guilt or no contest?
No contest.
Boxes were checked. Pleading no contest to 2 charges, is that correct?
That's correct.
First charge is that of operating while intoxicated. Second, that is a misdemeanor punishable by up to 1 year incarceration. Actually, I think that's a $1,000 fine plus court costs, isn't it? Say it, $1,000 fine plus court costs. The court could order community service, any rehabilitative services the court deems necessary. The court could also order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, ma'am?
Yes, I do.
You understand what a no contest plea is?
Yes, I do.
2 things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes, I do.
Second thing you need to understand is that for purposes of sentencing, the court will treat you this.
I was meeting with the officer today.
This was a department rep hearing today. 99% of these are resolved at department rep. That's been scheduled in for first. Unless somebody specifically requests an informal hearing. I'm going to set it for an informal hearing now. Can you give me the date?
Judge, that will be April 14th at 10 o'clock.
What's wrong?
I'm going to a wedding, but it's after that, that's fine.
Okay, so you're good with that date?
I'll take that date.
4/14 at 10 o'clock. Okay,
Thank you.
good enough. You can go down the hall, ma'am. We're gonna give you a notice, okay?
Okay.
Good luck. See you back here. Aditya Verma, 26W841-826. Morning, sir.
Good morning.
Your name?
I think they want one.
So they charge you with 75 and a 70. They think you were going 87 and a 70. They're gonna allow you to plead to impeding. Is that what you want to do?
Yes,
That's 0 points. It won't go on your record. You understand that?
thank you.
To that charge of impeding traffic, responsible or not responsible?
That's fine.
Plea is accepted, 155, cashier end of the hall to your right, and you're all set. Best of luck to you. All right, do I have everybody ready to go on James Martin? James Craig Martin, 24B 704-583. Sir, your name? You gotta unmute, sir.
I believe he met with Mr.
Yes.
Hayes.
Yeah, I'm calling right now.
You have to unmute in the bottom left-hand corner of your device there, sir.
Good. Oh,
There you
no,
go.
it's okay. Is that okay?
Yes, sir. Tell me your name.
Thank you, Your Honor. James Craig Martin.
We are going to get your lawyer in here right now. And I will have a hearing on this, okay? I'm sorry, you pled. Just wait till he comes in. We've called him.
Sorry, my grandson just woke up.
You're fine.
He's a bright spot in my life.
Good morning, Mr. Haynes.
Call.
This is Mr. James Craig Martin. This is the moving violation causing death. 24B 704-583. Okay, your name? Mr. Haynes?
Thurman Haynes, we have James Martin.
Mr. Martin, tell me your name again, sir, please.
James Craig Martin.
He pled guilty to failure to complete the community service. That was alleged to have been 80 hours by November 1 of 25. I took his plea. And on January 15th, I adjourned the sentence to March 31. This has quite a history to it. He absconded after the plea was taken, but before the sentencing. And I gave him 120 days jail. I think I gave him 40 then and 70 out on house arrest, and also said he had to do 10 days of community service. Your name? So that is the charge. He pled guilty. What would you like to tell me on his behalf?
Judge, I looked at the history, it looks like, even though the offense did in the 2023, he didn't actually get sentenced till April 8th, 2025. So
Because he absconded.
still has some time with him. He's indicated he's had some severe health issues the last few months.
All right, hang on.
You guys gotta take the phones out of the courtroom.
Come on, guys. You can't. Was it
Sir.
you, sir?
Is that your phone going off?
It was you in the glasses, wasn't he?
Whose phone went on? Whose phone just rang?
Come on, guys.
Whose phone rang? Take it out. Signs all over the building. Yep.
I never liked the idea of letting phones in here. Supreme Court told us we had to. They're supposed to be muted. We tell them that. They still come in here with the phones ringing. Every day. At least a couple, it seems like. All right, I'm sorry. I interrupted you. You started to say he's had serious health issues. I believe, I could be wrong about this. I think I adjourned the sentencing for 2.5 months so he could complete it because of health issues. Am I right or wrong?
That would track her. That would make sense. But still not done enough. The health issues are all recently started to resolve. He indicates he could have everything done by June 1st.
Well, remember, we're not asking them to walk up and down the streets and pick up papers. These are sedentary jobs. Do you have something more substantial? Did we receive any medical records?
I haven't received any current medical records. He did send me medical records in the past. I do believe that he does have some health issues. I'm not discounting that, but I did give him 2 locations to go to, both that I know would help with sedentary work, which is Fish and Loaves in Victory Gym. I haven't looked that he's completed any hours, so I'm not sure where we're at with those.
Mr. Martin, when you were the one I just told not to be smoking, if you got some health issues, I'm not your physician, but what are you smoking for?
I smoke a few cigarettes a day compared to 2 packs a day. A few years ago.
Why are you not doing the community service? Did you hear what Ms. O'Donnell
I
just
just haven't
said?
felt well. I wanted to put it off till it was warmer, just to be honest. And I just haven't felt well enough to do it, and I ran out of time. I paid for the course, the decision-based driving. I paid for that, but I still have to do it because they only do it every 3 months. I scheduled that a few weeks ago, and
No, but I placed you on probation in April of 25, April the 8th. Why is it taking you so long to do everything? I mean, I gave you until November 1st, probably again because of the health issues, to complete 80 hours of community service. And you had till November 1, then you didn't do it, then we show caused you, then you were in here in January. I gave you 2.5 months before I would sentence you. She tells me she sent you to 2 different places that she's confident you could have done the work at. You still haven't done it. Where's your medical records? Where's your medical records? Have you sent us any? Have you sent us anything?
You guys have my
I
medical
records
records.
from in the past, but current in the last couple months around here.
I just want you to know I just filed for Social Security, and not feeling well is probably something you hear a lot, but I just
I don't know who's talking in the background, but they can't talk and tell you what to say. That's not gonna
I
go.
don't feel good. Just plain and simple, I just don't feel well. My heart hurts the whole time.
Okay.
I did contact Fish and Wool. I know
When
what I
did you
gotta do.
when did you contact Fish and Loaves?
It was probably Saturday, I think.
Because you knew you had this coming up, right?
Well, of course, I wanted to at least pay for it. I mean, that's the wrong one.
Heather, give me a date the first week of May, please.
Sorry, Judge, I was muted. May
That's
6th.
May 6th at 8:30 in the morning. I'm gonna expect you to have that done. If you want to go to a doctor and get us proof within the next 3 or 4 business days that the doctor's telling us you cannot do the sedentary work at any of the 2 suggested places by Ms. O'Donnell, I'll be more than happy to give you more time. Okay, so you better go to your physician real quick and get us the medical records and a report saying you can't do the sedentary work at Fish and Loaves, or where's the other one? Victory Gym. No problem. I don't want you to do anything that's going to jeopardize your health, but it seems like you're putting it off. So that's what I'm going to do. May the 6th, 8:30, I'll expect it done unless you get us medical records here in the next few days and you request a hearing, okay, for an extension. Do we understand one another?
Yes, Your Honor.
All right. Good luck to you. Thank you.
Thank you.
All right, Derek Tanbelda Fernandez, 25W70753O. I'm gonna need you on this one too. All right, good morning.
Gotta go with him, Derek Fernandez.
So what I did is I hit a,
5 weeks is plenty of time.
can you mute him, please? Mr. Hernandez, your name, Mr. Fernandez, your name?
Derek Fernandez.
So here's what happened in this case. He pled guilty to failure to attend the domestic violence program back on October 7th. He failed to provide proof of completing 31 hours of community service by October 20. He pled guilty to those violations in front of me on December 4th. I went ahead, set a sentencing date for January the 6th, I believe, at 10 o'clock or 10:30 in the morning, rather. I told him to get a job and get back in mental health treatment. He didn't show up on January the 6th. I issued a warrant. We adjourned the sentencing then on March the 3rd, and here we are now. Please tell me there's been progress. Tell me what there is.
He was hospitalized January 15th. I think he walked out on March 3rd. I believe he was got out today.
Okay.
Standing, everything's been completed.
Is that true? Oh, good. How you doing?
It's been a rough year, but
You seem like you're doing better.
yeah, I can chug along.
I'm sorry?
Chug along.
That's all we can do in this crazy world is chug along, right? I mean, I don't know what else to say. Good. Well, then I can go light. That makes it easy. Is he working?
No, Judge.
I'm looking.
Judge, he's got a review date coming up in April.
April the 21st. I'll tell you what. I'm not going to do anything, believe it or not. This is 2 technical violations. I know you've been struggling. He only pled, by the way, on the domestic violence. He did his community service, so I believe we moved to dismiss that. So we have 3 technical violations, total 1 here. I know you've been struggling with some issues, and I'm glad to see that you seem to be doing better and that you're following the orders of the court, and I'm not going to do anything. I'm simply going to assess no fines or costs. Stay out of trouble, continue doing what you're doing. Come on back on April 21. This was taken under 7694A. In this case should be dismissed. And I wish you well. I really do.
Thank you.
Good luck.
Yeah.
You're smiling a little bit, right?
Yeah.
Good. Okay. Have a good day. Which other one
Thank you.
do you have?
Do you have Pentel?
Can't tell?
Brandon Pentel?
Yep. Okay. Brandon Ross Pantel. 24B147651.
What is that, Mr. Pentel?
Sir, your name?
Brandon Ross Pentel.
All right, so it looks like he pled guilty to both violations, failure to register and attend and complete the positive strategies program, and failure to pay fines and costs. That was back on March the 3rd, at which time I revoked his status, entered the conviction, and set it for a sentencing date. So his 771 status I've revoked.
Right.
So I'm ready to sentence him. I will need Ms. Wilds in here. Can you give me a first page of a register, please? Why isn't what's going on? This is 5 technical violations.
Just everything's completed now. I understand Ms. Lyles had her door closed, but I was able that they spoke this morning. He actually double checked yesterday the programming. That revocation in yesterday, and she has received it.
All right, so you tell me all the fines are paid. He's done everything that I ordered him to do, and that is positive strategies program, no contact with the victim, 2 days court work, not to enter the property address at 18427 Telegraph. I allowed him to leave the state. He paid all of his restitution and fines and costs, which is pretty hefty given the restitution was $640, right?
Yes.
So he's done everything. I want to just confirm that, not that you would misrepresent. I know you better than that, but I do need to call her and just verify. Okay. Is there anything else that you'd like to say, sir?
I just want to apologize to you, Ms. Lyles, my family. It's a terrible experience, and I've learned a lesson, and it's going to move on and be a better person because of this. And
Just what's your name?
Elizabeth Busby, Your Honor.
He's done everything now?
He has, Your Honor. I just received proof yesterday, completed the economic.
Good, good. I can go light then. Anything else?
That's where the fault would have to be close.
I'm gonna charge him $100. Any 50 fines, 50 costs, $100 or 30 days. You can go down the hall and pay that. You have that now, right?
Yep.
Go down the hall and pay that. Unfortunately, the conviction has to remain, but you are all set and I wish you well. Good luck.
Thank you.
Thank you.
Thank you, Your Honor.
Devon Harris, 26W891883. Do you have another one?
I do. I've got Deanna Long.
Okay, let me get a couple of these out of here. And Devon Jarrell Harris, 26W841833. Good morning, sir. Your name?
Devon here.
Okay, so you met with the department rep and you are going to plead to impeding traffic, true?
Yeah.
Okay. And then they are going to dismiss the 75 and the 7. To that charge of impeding traffic, responsible or not responsible? Okay. I'll accept your plea. Got to be careful though, okay? 175 is your total. I'll make it 170. 170 is your total. Cashier into the hall to your right. Good luck. Brandon Roberts.
I have to get it together.
You don't have the money. Wait right there, Mr. Roberts. Do you not have the money?
No, right now.
How much do you have today?
I really don't have anything.
Are you working?
Yeah.
Where?
Permanent transportation.
How much do you make there?
Lucas.
You're making good money. You're not doing a very good job.
Huh?
You're making good money. You're just not doing a very good job of saving money, right?
Well, no, I got bills.
We all got.
That's right.
All right. Tell me when you can pay.
About a week.
Okay, no problem. I'll give you until the 14th. And listen, if you need more time, not a worry. Call the court. We'll go on Zoom on or before that due date. I'll be glad to give you an extension. Okay. Best of luck. April 14th, 170. Come on up, Mr. Roberts. Brandon Roberts, 26W841763. Good morning, sir. Your name? All right, Mr. Roberts, you're charged with limited access speed. They charged you with 75 and a 70 from an offense date of March the 1st. Now they're offering you impeding, and I understand you wish to plead to that. True?
Yes, sir.
To that charge of impeding traffic. Responsible or not responsible? Okay, I'm going to accept your plea of responsibility. I'm going to assess fines and costs of $160. You can go down the hall and pay that, and you're all set.
Right.
Good luck. All right, people against Barton, Justin, James Barton. 26 T6 47841. Could I have John Schwartz over here seated at the table, please? Mr. Barton, good morning. Your name?
Justin Barton. Good morning.
All right. So you are going to plead to, well, you want an informal, right?
Correct.
Okay. We'll set an informal on this. What do you have for me?
April 14th at 10:15.
April 14th at 10:15. You can go down the home and get your notice, okay?
Thank you, Your Honor.
Best of luck. Thank you. John Schwartz, 26P. 647-837. Good morning. Your name?
John Sharks.
Sharks. I'm sorry. Okay, so I'll set for informal if you want.
I was hoping you just listen.
I can't just dismiss it, sir. I can't. That's not my province. They got you going 65 and a 50. He wrote you for 55 and 50. If you want.
He was set for an informal today.
Oh, it was?
Yes. We adjourned it last time for an informal for today.
Oh. Well, you're entitled to it.
Brent, sir, if she wants to explain it.
Okay, this is 26T 647-837. This is Mr. Sharks. Your name?
Officer Mounts.
Okay, tell me what happened.
So the officer is actually out. the state right now, so he's on vacation, I can't get a hold of him in reference to the citation.
If he came here, I've got to dismiss this. I just want you to know.
Okay.
Okay? If they give us notice, we'll reschedule, but I just can't do it. So, sir, I'm gonna give you a dismissal. You're all set. Officer failed to appear, case dismissed. Best of luck. Best of luck. Thanks, officer. Let's see here. Angela Bedelia Keel. 260-647-743. Good morning. Your name? Well, you come up here with a smiling face.
Yes.
I don't see a lot of smiling faces here sometimes. It's nice to see. You're going to plead to impeding, right? Responsible or not responsible to that? You came all the way from Chesterfield.
My sister lives down here.
Oh, so did you get to spend the night and have fun? That's how you got the ticket.
Yes, I was visiting her.
That isn't fun. To the charge impeding, responsible or not responsible?
Responsible.
You got a clean record, 150, please accepted, 150 or side. Best of luck. Thank you. LaChapelle, Lawrence Daniel LaChapelle, 260-647-412. How you doing, sir?
Yeah.
You got a clean record.
Yes, sir.
You're gonna plead to impeding?
Yes, sir.
Your name?
Lawrence Daniel LaChapelle.
All right, to that charge of impeding, responsible or not responsible?
Responsible.
Plea is accepted, 150 is your total, cashier into the hall to your right, and you're all set.
Thank you.
Have a great day. Good luck.
Thank you, sir.
You're welcome. Gee Neely. Janaya Amani, Ariane Gee Neely, 25W839-829A.
Good morning, Denai Janelle.
I got a slew of violations for you. I sentenced you on February 4 of 26. I'll go through the violations one by one with you. We'll go from there. Count one alleges that you failed to attend the court work program on February 21 of 26. Do you understand the charge?
Yes.
Count two alleges that you failed to enroll in weekly testing as ordered on February 11 of 26. Do you understand the charge?
Yes.
Count three alleges that you failed to enroll in weekly testing on February 16th of 26. Do you understand the charge? Count four alleges that you failed to refrain from consuming alcohol. Sober link blows. Failure to submit on March 4th at 7 a.m., 3 p.m., 7 p.m., and 11 p.m. You understand the charge?
Yes.
Count five that you failed to submit to sober link blows. That would be on March the 5th at 7 a.m., 11 a.m., 3 p.m., 7 p.m., and 11 p.m. Do you understand the charge?
Yes.
Count six, you failed to submit to sober link blows March the 6th, 7 a.m., 11 a.m., 7 p.m., and 11 p.m. Do you understand the charge?
Yes.
Count seven, you failed to submit to sober link blows on March the 8th, 7 a.m., 3 p.m., 7 p.m., and 11 p.m. Do you understand the charge?
Yes.
Count eight, that you failed to submit to sober link blows on March 9th at 7 a.m. and 11 p.m. Do you understand the charge?
Yes.
We have
I'm sorry.
23 counts. Failure to submit to sober link blows is ordered on March the 12th. At 7, this is count 9, at 7 p.m. and 11 p.m. Do you understand the charge?
Yes.
Count 10, you failed to submit to sober link blows on March 13th at 7 a.m., 3 p.m., 7 p.m., and 11 p.m. Do you understand the charge?
Yes.
Count 11, that you failed to submit to sober link blows is ordered on March the 14th at 7 a.m. and 11 a.m. Do you understand the charge?
Yes.
Count 12, that you failed to submit to sober link blows is ordered on March the 15th at 7 AM and 11 AM. Do you understand the charge?
Yes.
Count 13, that you failed to submit the Soperlink blows on March the 16th at 7 AM. Do you understand the charge?
Yes.
You gotta keep your voice up.
Yes.
Count 14, that you failed to submit the Soberlink blows on March the 17th at 7 AM and 11 AM. Count 15, you failed to submit the Soberlink blows on March the 18th at 7 AM and 11 AM. Count 16, you failed to submit the Soberlink blows on March the 9th at 7 AM and 7 PM. You understand all those charges?
Yes.
Count 17, you failed to submit the blows on March the 20th, 7 AM and 3 PM. Count 18, you failed to submit the Soberlink blows on March 22nd, 7 AM, 11 AM, and 7 PM. You understand the charges?
Yes.
Count 19, you failed to submit the Soberlink blows on March the 23rd at 7 AM and 3 PM. Count 20, you failed to submit the Soberlink blows on March the 24th at 7 AM, 11 AM, and 7 PM. Count 21, that you failed to submit the Soberlink blows on March the 25th at 7 AM and 11 AM. Count 22, you failed to submit the Soberlink blows on March the 27th at 7 AM. And finally, count 23, that you failed to submit the Soberlink blows as ordered on March the 29th at 7 AM and 11 AM. Do you understand all charges here, ma'am?
Yes.
If you plead guilty, if you're found guilty, these are all arising out of different events, transactions, or occurrence. Your probation could be revoked. You could be incarcerated for 93 days. Do you understand that? Did you sign, read, and understand an advice of rights form here today?
Yeah.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
All right, you have the right to a lawyer. I'll be happy to provide you with one at public expense. Do you understand that?
Yes.
Would you like a lawyer?
Yes.
I'll give you one. You go meet with the attorney, then you'll come back in front of me. Any questions?
No.
Good luck.
Casino Hall.
McCarter, Kathleen Matuzak McCarter, Q6T647640. Can I have Karnick and Langston seated at the table, my right and your left? McCarter, come on up to the podium, please. Ms. McCarter, Kathleen Matuzak McCarter, Q6T647640, and tell me your name.
Morning, Kathleen, Suzak McCarthy.
You're going to plead to impeding, right?
Yeah.
Responsible or not responsible to that? Plea is accepted. I'm going to go ahead and assess fines and costs of $150. You're all set. I wish you well. You can go right down the hall and pay those. Good luck. People against Kevin Joseph Koenig, Q6T647802. Your name, sir?
Good morning, Your Honor. Kevin Joseph Connor.
Good morning to you. You are going to plead to, I believe it was impeding. Yes, impeding traffic. True?
Correct.
To that charge of impeding, responsible or not responsible?
I am responsible.
You got a clean record, 150 is your total, the speed's dismissed. You can go down the hall and take care of that. You're all set.
Thank you, Your Honor.
Best of luck. Raheem Langston. Raheem Langston, 267841806. Defendant failed to appear. She is responsible by, I'm sorry, he failed to appear. He is responsible as charged by default, 26W841790. Default judgment entered against Mr. Bryant. I also have two 6W841808. He failed to appear on. And I'm going to go ahead and give him a default judgment on that one as well. The failure to appear,
Those two different
it looks like it.
people, I think.
Let me see. See, that's why you hire good help. Because they can correct you when you're wrong. And I gotta tell you, oh, you are so right. Wait a minute. What happened? They put one of these in the wrong box. My mistake. So I'm gonna redo this. For Sean Lamont Bryant Jr., 26W41790, responsible as charged by default. Raheem Ibn Asim Langston, 26W41808. Same with him, responsible as charged by default. Thank you for catching that. People against Kent, Justin James Kent. 260-647-969. Good morning. Your name?
Justin James King.
You are going to plead as charged to holding, I'm sorry. Let me see, my mistake. No, you want an informal.
Yes, please.
We'll set an informal, my mistake. Give me a date on this one.
April 14th at 10 o'clock.
Good enough. April 14th at 10 a.m. You're gonna go down the hall and get your notice and you're all set. Best of luck. Law. Do I have Dion? Did you talk to your lawyer yet? Who's your lawyer?
Mr. Haynes was, I believe that's the other
Okay.
one he said he was ready on.
Zamet, Benjamin Adam Zamet. No, don't let him, he's got others, I'm sorry, 260-647-951. Your name? You're going to plead to impeding, right? Responsible or not? Not responsible to that. Now listen, how old are you? You got a careless and you got another ticket and you got this ticket. You got to be careful. Who you with? What's that? The young lady back there. Huh? You're not going to have a young lady if you don't have a license, right? Because they don't want to hang out with guys that have make them push the cars down the expressway, right? To the charge impeding, responsible or not responsible. All right, I'll accept the plea to impeding 175. You're all set. Good luck. Please slow down your record. Your insurance company will send you a gift package. Good luck. Tressler. Rodney. Richard Tressler Jr. 252M307186. Your name.
Good morning, Your Honor. Trustler.
Still isn't paid?
I'm close. I could have a balance paid of 2 or 3 weeks.
You're running out of time. Let me check something here. I can't give you any more extensions, sir. I can only keep you on probation for a period of 2 years. That's the 9th.
So I know.
And the charge here is that you failed to pay your fines and costs as ordered, balance owing $3,546. I'm gonna have to go through the full arraignment here. Do you understand what I'm telling you? I'm gonna have to arraign you. And we're either going to have a hearing, or you're gonna have to plead guilty. I want to give you a lawyer. He charges that you failed to pay your fines and costs as ordered, balance owing $3,547. This is primarily all for the record on restitution, right? I mean, just, I know
it's 1900 at the moment.
But as of the date of show cause, March 11th, that was the balance allegedly, and I need to arraign you, and we need to go from there. If you plead guilty, or if you're found guilty, you could be incarcerated for up to 1 year. You understand that? And did you sign the advice of rights and read and understand the rights? If you plead guilty, you'll be giving up all those rights, and we are not going to have a hearing. Do you understand that? If you plead guilty, no, I'm just telling you, if you plead guilty, we're not going to have a hearing. You understand that? If you plead guilty, we're not going to have a hearing. You understand that, right? Slow down. Yeah, I just want to make sure you understand that. Do you understand what I just said? You have the right to a lawyer, and I would be happy to give you one. I think you need one. So I'm going to give you a lawyer. I'm entering a not guilty plea for you, okay? And we are going to have a revocation hearing today. And that's it. So I will indicate that I am going to enter a not guilty plea. I'm going to give you a lawyer. You're going to come back in with the lawyer and we will go from there. I'll enter a not guilty plea for purposes of arraignment. So you can go down, go sit in the hallway and you will bring this out and we will give you an attorney. Any questions? Okay, good luck. Feels a lot better in here now, doesn't it? People against Roth. John Paul Roth, 260-648-02. Could I have seated up at the table here, Nieberdowski, Sarah Nieberdowski. All right, sir, your name?
John Roth, RFK.
All right, Mr. Roth. Let me see what they offered you. That person usually ordered. You're going to plead to impeding, right?
Yes,
Responsible or not responsible to that?
responsible.
You're all set. 150, please accept it. It won't go on your record. Go down the hall and make your payment.
Okay.
Prohibited terms dismissed. Good luck. People against Sarah Marie Nieberdowski, 260-647-850. Defendant must not have shown, right? Defendant did not show. Responsible is charged by default. All right. People against Peters. Justin Edward Peters, 260-647-986. Could I also have seated at the table here, Abraham, James Abraham. Sir, your name? All right, how you doing today? You are going to plead to impeding. All right, most of your bad driving happened years ago. To that charge, responsible or not responsible? All right, at 160 is your total. Cashier into the hall to your right, and you're all set. Best of luck.
Thank you.
All right. James Asif Abraham Jr., 260-648-005. Good morning, sir. Your name?
James Abraham Jr.
All right. How are we doing? Good?
Well, sir.
Pardon?
Well, thank you.
Good. You're going to plead to impeding, right?
Yes, sir.
All right. To that charge, responsible or not responsible?
Responsible.
Why are you texting?
I was actually talking on the phone, but I just left work. I was just
I know, but
gonna
you
down
just-
with the kids and everybody.
I see these people texting and talking and I'm sorry. I don't understand it. $200. You're all set. Cashier into the hall to your right. Good luck. Thank you. Thornsberry, Johnny Luke Thornsberry. Come on up, sir. 25W839358. Well, I'm gonna go. Did you hire one?
No, he's the guy with the dark skin. And very good.
He already talked to you?
Yeah.
Okay, well, I'll just wait for him then. My apologies.
Yeah.
Have a seat, okay? Do I have Gage Cartier here? They gave me this one early. And well, that was just for informal, so I'm gonna hold that one. How about Alandis Young? 2OB710-244. How's it going, Mr. Young?
Oh, it's good to see you. Say thank you. Being
You thank me for being lenient?
Yes.
Have I been too nice?
Yes, you have.
I've been too nice?
More in the,
I've not had too many people tell me I've been too nice before.
well, I've been given time by you.
I know you
One
have.
day you made me like cry because you said, I want to put you in jail. and he said, work at McDonald's, and now I'm ready to go. Pay my bond. I pay the bond.
Heather,
I live in South Carolina.
do you?
Yes, sir. My wife, me and my wife.
Is this your wife?
Yes, sir.
How you doing?
Thank you.
Did Heather, help me with this one?
Mhm.
You
Yes,
didn't
sir.
show up you didn't show up in 23, right?
Yes, yes, sure. And thank you, ma'am.
Is that-
I'm sorry. What was the name on this one, Judge? I was given a file.
That's okay. You got a lot going. I get it. Alandis Young, 20B710244.
Okay, and what was the question for this one?
The question is, has all of the restitution, let me just double check.
Been paid?
Has all the restitution been paid?
No, there's still a balance of $350 on the restitution.
Well, I would let this go.
I got it.
I would let this go. And this is Suzanne Straw, right?
Yes.
Look, how much does he owe right now?
350.
Is that it, Heather?
Yes, Judge, that's all the balances. It's the 350 of restitution.
Okay. If it wasn't for the restitution owed, I would just waive the balance, but I can't when there's a victim's owed money, so I'm sorry. We're just gonna short circuit this. I'll apply the bond, and she's gonna let you apply the bond, right? Yes?
Yes, sir.
Apply bond to payment of fines, costs. And the case is closed. Okay, let me just check something here. You should have come and talked to me in
Yes, I
23.
should. Yeah, I'm sorry, you've been very eager, that's why I said it. The time has run by.
I know. It's going too quick, don't you think, Mr. Young?
Yes, sir.
Geez, you and I were born the same year, I think. Let me see here.
It's good.
It's going awful quick. You got me by a few. Who's crying? We'll apply the bond and Kate close the case, Heather. Go down the hall and take care of this.
We'll find out. Thank you.
Good luck to you. You're living in South Carolina?
Yes, sir.
How nice is that?
You-
Good luck.
Thank you, girl.
Have a great day. Good luck, Liam.
You called this case, the one guy showed up. He's still in the courtroom here. I don't know why there's another guy showed up at the podium when you called this case. But
Who showed up when I called Ali Al Hassani?
So what happened there, Judge, is I believe you called one up to the podium and one to sit at the table. And I think the one that was supposed to sit at the table came up. And so when those files came down, that guy came up to the window. We took care of him because you did call that case too.
Wait a minute,
So
I got
Alice-
somebody crying in the lockup here
The hallway.
or in the hallway or something. I don't know what's going on. Okay, I want to make sure. Good luck there, Mr. Young.
Thank you.
All right. Heather, I'm lost. What happened? Somebody else
So-
came up. Is that person still
Yeah.
here?
No, they came up. It was Alec Johnson, I believe, came up in place of Ella Sani, and the files were down here.
Where's Alex Johnson at now?
He is gone.
Well, what? Now I am completely lost. How did we
So Alec Johnson also did have impeding.
say
But the
again?
So the files got mixed up, is I believe what happened, because that's when Amy came down. to
Reschedule
grab
the other
files.
one then, right?
No, they were both written up.
I know, but I told that guy I would let him pay 75 now and the balance 50 bi-weekly beginning April 14th. Mr. Johnson is.
Correct.
Well, we got to reschedule his, right?
Mr. Johnson was the one that was at the podium.
I know.
That's
But
the
I
one
didn't-
that you did. but Mr. Alisani, you did not do. But
You
it was
just wrote
written on his
Johnson's
file instead of Mr. Johnson's file.
What am I gonna do with Johnson now? Was he entitled to impeding?
Yes, he was. So
So
you
I'll-
gave him the correct stuff. It was just written on the wrong file.
All right, just make sure everything's correct down there, will you please? I'm sorry that happened.
Yes,
Ali-
it is, Judge.
Ali Abdullah El Hassani, 26T 647-961. Good morning, sir. Your name?
Yes, sir.
Your name?
Yes.
What's your name?
Ali,
Ali what?
Al Hassani.
All right, you're going to plead responsible to impeding traffic, right?
Yes.
To that charge, do you plead responsible?
Yes.
Responsible? Okay, I'll accept the plea. I'm going to go ahead and dismiss your prohibited turn. And I'm gonna charge you $160, okay? 160 on this guy. Can you pay that today?
Yeah, I will be.
That pleads to impeding 160. So Heather, I'm gonna leave the other on this register, and I'm gonna let you fix it, okay?
Okay, Judge.
All right, go down the hall, 160. Please accept it to impeding. Good luck.
Thank you.
Is Johnny Luke Thornsberry here? You're the one with Mr. Haynes, right? Mr. Law, I think, is with Mr. Haynes. Ms. Dean Neely is with Mr. Haynes. And this needs to go, John, my apologies, that has to go in the Landis Young file.
Mr. Haley, working on one more.
Okay. Ma'am, you can't carry on like that, please. Okay? I'm gonna take a recess until Mr. Haynes is ready. Everybody can stay seated. Thank you. Oh, here he comes. All right, which is your pleasure, Mr. Haynes, and what, are you here on Cartier?
Yes, sir.
Yeah, is Mr. Cartier here?
I got you.
Either by Zoom or in person,
Judge, I
Heather?
need to find out who's in county here. We just have county in.
This is just a civil infraction informal. I
Oh.
doubt that's him.
So yeah, that wouldn't be him.
Well, just keep an eye out for Mr. Cartier by law, I give everybody 15 minutes. So I'm gonna give him till
Right.
1:45, scheduled at 10:30. Who's easiest?
I think Mr. Law would be next for me.
People against, Deanne, Tella, DeWande Law, 25F. 243345A, B, C. 25B148445A. All right, his name?
Through an inspector, yeah, Law, he's gonna plead guilty to clear these matters.
Does he have some money?
He's back to work.
I know, but we've given him payment plans and he has not complied. And honestly, I just want to caution you. I mean, I'm not going to keep doing this. Sir, let me talk to your lawyer, right?
Yes, sir.
You just can't do this. You just can't do this. You don't pay.
I made payment, but I haven't completed that.
You're not even close. Where's he working?
I'm working at his board.
Oh, yeah, you told me.
The hiring
A
process.
phlebotomist. How much do phlebotomists make these days?
I don't know how much they make, but I make 21 an hour,
How many hours do you work?
full time right now.
Kids?
Sorry, working briefly.
Kids?
Yes, I'm full time, father of 2 kids. My mom helped me a lot from kids as well, so I'm able to work.
I'm not gonna take his plea. I'm adjourning these for 5 or 6 weeks. Give me a date, May the 16th, 15th, somewhere in there, Heather, please.
Of this month, Judge?
May,
I'm sorry, of April,
May.
of May, okay. We could, well, let's see. We could do the 14th of May.
14th is fine. What day of the week is that?
That's a Thursday.
You're gonna be in here at 8:30 in the morning, okay? Now, I'm gonna tell you, I'm gonna expect you to put a dent in these. I don't know why you're doing this. I don't know why you're not calling when we invite you to call. Listen what I'm telling you. Please don't interrupt me.
Sorry.
I don't know why you're not calling and talking to us when we've invited you to call and get an extension. You're just not doing that either. So I'm telling you, my patience is kind of running thin with you. I don't like it. And gave you payment plans and gave you a break and you just keep asking for more and more and more. I'll indicate he stands mute on the misdemeanor. Fair? I'll adjourn the other ones. We'll adjourn the hearing on that.
Is the misdemeanor not adjudicated?
It's adjudicated, but he goes 340. So I'll adjourn the hearing on that contempt and I'll adjourn the hearing on the other contempts to May the 14th at 8:30. You can go down the hall and get your notice. You know, all you have to do is be reasonable with this.
I understand. That's happy to be.
All right. Well, good. Good. I look forward to it. Thank you.
Thank you.
All right. Let's do Mr. Tressler here. Rodney Richard Tressler Jr. 22M 307-186. He's got all kinds of restitution. I'm running out of time. He's only got 9-10 days left. Probation runs out on the 9th, so he's got 9 days left.
Judge says it's working on the job and won't have it paid by then. The whole.
You can take a plea from him and I can go from there. You want to do that, Mr. Tressler? Your name?
Rodney Tressler.
All right, so I already covered your rights. You understand you plead guilty, you could get 93 days, correct?
Yes, sir.
And you understand all your rights that we just covered, right? If you plead guilty, you're giving up all of those rights and we're not going to have a hearing of any kind. You understand that?
Sure.
To the charge you failed to pay as of the date of the show cause, $3,547. How do you plead? Mr. Tressler,
Yes, sir. I'm sorry.
I'm not going to send you to jail today if that's what you're worried about. So how do you plead to that charge? Failure to pay. Pardon?
Guilty.
Did you fail to pay all the amount? I mean, there was an enormous amount of restitution you owed on this. Did you fail to pay as of the date of the show cause, $3,547, correct? And right now, as of today, you owe how much? Did he pay the other 1,000 or something? The last payment we show is March 13th.
It would have been yesterday, the day before.
Is that what the balance reflects, Heather? 1,900 and some?
Sorry, Judge. I went on the wrong screen. He has, 1950 is the balance.
Anybody force you to plead guilty? All right. When can you pay this by?
I have had about 8, I'll do about 8.
Let's set it for sentencing on the 8th. We're going to set a sentencing April the 8th. And you can come in with the money. We'll set it at 9. If you paid it, I'm not likely to do anything.
Thank you.
Okay? That's what I'll do. So the guilty plea is accepted, sentencing on that date. Wish you well. Thank you. Still have to give them 10 minutes. How about Thornsberry? Wait.
Right. Next 2 matters of Ms. O'Donnell's.
Okay, let's call in Ms. O'Donnell on those. Johnny Luke Thornsberry, 25W839-358. Your name, sir?
Johnny Luke Thornsberry.
All right.
Violation from Thornsberry, pleading guilty to all of them. We talked about this very tough.
This is an amended order of show cause, right?
Yeah.
Okay. Is that what you want to do, Mr. Thornsberry? I'm just asking you, is that what you want to do?
Yeah.
So you have an amended order of amended show cause here that alleges that you failed to refrain from consuming alcohol or drugs testing positive for a cocaine metabolite on February 23 of 26. That's count one. You have count two, failure to submit the testing as ordered on March the 13th of 26. Count three, you failed to refrain from consuming alcohol or drugs, testing positive for cocaine on a chemical test of March 19th. Count four, you failed to submit the weekly testing as ordered on March the 25th. And count six, that you failed to pay your fines and costs as ordered, balance owing as of the date of show cause of $880. Do you understand those are the charges?
Yes.
You understand you plead guilty to those charges, that your probation could be revoked, and you could be incarcerated for the maximum provided by law, which in your case is up to 90 days. Do you understand that?
Yes.
And did you sign, read, and understand an advice of rights form?
Yes.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing. Do you understand that?
Yes.
All right. I'm going to ask you to look at me and tell me as to count one. How do you wish to plead to the charge that you failed to refrain from consuming alcohol or drugs, testing positive for a cocaine metabolite on February 23 of 26? Did you test positive for a cocaine metabolite on that day? Had you consumed cocaine within the 7 days preceding that?
Yeah.
Count two, that you failed to refrain or failed to submit the weekly testing as ordered. And March the 13th. How do you plead to that?
Yeah.
Okay. I act like you're kind of acting like I'm keeping you awake here.
No,
I'm asking you, how do you plead to the charge you failed to submit the testing as ordered on March the 13th?
Guilty.
Did you fail to submit the testing that day?
Yes.
For the charge, you failed to refrain from consuming alcohol or drugs, testing positive for cocaine on March the 19th of 26. How do you plead?
Guilty.
Did you test positive for cocaine on March the 19th, and had you consumed cocaine within the 7 days before that?
Yes.
Count four, that you failed to submit the weekly testing
Yes, sir.
as ordered on March the 25th. How do you plead?
Guilty.
Did you fail to submit the testing as ordered on March the 25th of 26?
Yes.
And count six, finally, that you failed to pay your fines and costs as ordered. How do you plead?
Guilty.
Did you fail to pay your fines and costs as ordered?
Yes, sir.
Does he still have a balance of $880, Heather?
Yes, Judge.
Anybody force you to plead guilty?
Nothing.
Pleas are accepted, counts 1 through 6. Your name? Ooh, this isn't good.
Judge, if I could.
Yeah,
I know it doesn't look great, and we just got sentenced. Johnny's been very honest with me about his use, his issue of not having money to test. He's in a much better situation than he was when he was sentenced. He does have good employment now. He's just getting paid. I believe his first paycheck is tomorrow or sometime this week. He is back enrolled in treatment. He's doing well at Team Wellness. He sees both a therapist and a psychiatrist. If everything goes as planned, if everything for testing goes well with the treatment center, he will be on Suboxone later this week. I think that's a good option for him. I think that's something that'll help him moving forward. Again, he's very honest about his use and need for help and things like that. And I think his employment was something that was struggling with it. So when he did have money, he always showed up for testing and everything like that. It wasn't always negative, but he did show up. Again, I think getting on Suboxone and getting back enrolled, he'll be an IOP soon as well. I think that'll help him out a little bit.
you're riding to the rescue.
No, he's being.
Reminds me of an old John Wayne movie. You know that? I mean,
I think he would have been a good.
I get it.
candidate.
Hey, listen, you've been straight with me the whole time. All right, here's what I'm gonna do. This can't go on anymore. You're gonna kill yourself. I'm gonna adjourn your sentencing now. I expect you to show for testing, and I expect you to be negative for testing. Now, let's get this straight. When did he last test?
The last test I have for him is going to be that March 19th.
If I send you for a test today, are you going to pass though?
I'm not sure. It's been 4 or 5 days.
So you consumed still 4 days ago? So she's just singing your praises here and you're still using.
I'm struggling.
Okay, that's fair. All right, so what do you think we could do to help him get through this?
Again, I think if he stays clean by Thursday, he'll get on Suboxone. I think
Yep.
that'll help a lot with his
All right.
meetings and things like
All
that.
right, let's do this. I'm simply going to, I'll accept all those pleas, as I said. I'm going to Excuse me. Give me a sentencing date, Heather. In about 3 weeks, please. And let's see how he's making out then. Somewhere around April the 21st.
We could do the 22nd, Judge. Does that work?
At 8:30, okay? You got to make a better effort. I'll adjourn your sentencing. Suboxone is great for you, but you're still going to have to do this on your own. You follow me?
I didn't hear what you said.
I said, I'm glad you're going on Suboxone. But you still got to make up your mind you're not going to use. You understand?
Yes.
That's what we'll do. Thank you. All right, good luck. Do I have,
Judge, can we get
do
the
I
name
have-
of who's in county?
what's your name, sir? Sir, yeah, you,
Eric Brackman?
Brackman?
Yes, sir. Yes, Your Honor.
I believe he's supposed to be in Judge Hessen's courtroom.
So can you get the deputy and we'll chat? Can you chat with him, Heather, and tell the deputy what Zoom ID he needs to go into?
Yes, I'll send a chat to them.
Okay, so we'll mute them and right now. Is
Thank
Gage
you.
Cartier here? Let's do that one. And then I'm gonna do on Ms. Neely here, D. Neely, and then I'm gonna do this one. Cage Maximus Cartier, sit 26 F 245 How you doing there? Your name?
My name is Gage Cartier.
Mute them if you would, Heather.
I'm supposed to be in Judge McNally.
No. Your name?
Officer Griffin Garland, Fire Police Department.
So here's the deal. I think he requested informal because they didn't offer him anything. And if they didn't offer him anything because he hurt somebody, then the defense so I want to know, was there injuries to the other drivers or passengers of the other vehicle and or was there serious damage to the other vehicle?
Your Honor, I believe the other vehicle was towed. I believe it was totaled. I don't know the full extent of the damage. I don't believe there was any airbag movement. And I don't believe there was any injuries from either party.
So I don't mind if you offer him a 1-pointer, but if he's totaled the car, that's the best I can do. Okay? So if you want to plead, what street was this on? Telegraph? Right there was the speed limit, what, 50 or 45? 45. So do you mind offering him 50 and a 45?
Do that, Your Honor.
Do you want to take that? If you do, that's 1 point. It is going to go on your record.
Is there any way that we could drop it to?
I can't do any more than that.
All right, then yeah, I'll take that.
So the charge 50 to 45, responsible or not responsible?
What was it?
Responsible or not responsible to 1 to 5 over?
Responsible.
I'll accept the plea. 195 is your total. Go down the home, pay that, and you're all set. Okay?
Okay.
Good luck. Thank you. Do I have Jessica Colbert here? Jessica Colbert. So we're just going to set this for an informal, right, ma'am?
Yeah.
Your name?
Jessica Colbert.
All right. We're going to set it for an informal, and that will be what, on April the 14th, Heather?
Correct, Judge. At 10:15.
At 10:15, okay?
Okay.
You can go down the home, get your notice, and you're all set. Kira Nicole Catalano, 260-647-985. Catalano? Is she here? No. Default judgment, defendant failed to appear. What else do I have? I have a
Flat Rock in custody.
We have a Flat Rock in custody.
Ready.
Are they waiting out there?
They are waiting.
Who's on that one?
Okay.
Brandon Christopher Misselif, 24F242829. All right, Mr. Westmoreland, good morning. Your name?
Good morning, Your Honor. Attorney Corey Westmoreland, appearing on behalf of Mr. McAuliffe.
McAuliffe, your name?
Brandon Christopher McAuliffe.
Officer, your name?
Sergeant Jeremy Mullins, Flat Rock Police Department, Your Honor.
All right, good afternoon, Sergeant. So I had him, I took his plea on September the 25th of 25 to a probation violation. I'm gonna need somebody for Emily on this one, somebody for Emily. And He was found guilty or pled guilty to failure to submit the monthly testing as ordered on August 12th, again on September 16th, failed to clear his warrants by July 26th. We did with regard to the outpatient treatment. I'll find that out in momentarily. I set it for sentencing. Show up on October 1. So that's where we are. What does he want to do here? So I'm going to sentence him on the charge. And I don't know what else there is to do. Apparently he didn't want to come to court, I guess. So that's what, that never bodes well for you. So you could get, I just want you to be aware, Mr. McCall, 90 days on these. Do you understand that?
I do, sir.
Where was he?
Your Honor, he indicated to me that he thought probation was closed out and finished. He's lives in Flat Rock. He is gainfully employed at Richmond Recycling. He was in a bad car accident last November, and that's kind of all.
He thought probation was closed out.
No, to be honest with you, sir.
Well, yeah,
I
don't want people. Come on. What do you mean?
I'm
You
not.
thought probation was closed out?
That's not what I said. That's not what I
Okay,
said.
well, tell me what the explanation is as to why you weren't here for sentencing back on October 1.
There is no excuse for not being there, obviously. But at that point, I was in a bad situation. I couldn't afford, I got in the accident. I lost my job. I was in the process of losing my home. And I
thought your lawyer
really
just told me the accident didn't happen until November.
Correct.
Well, this had nothing to do with you not being here October 1st then. The accident had nothing to do with that. The accident hadn't happened for at least another month.
Right. This was, I know, I'm sorry, we're leading up to that, but there are just a number of events before that, like I said, I lost my job. I was almost lost my place, and I didn't have the money. I didn't have the means of transportation. I didn't have any of that. So I was trying this whole time from this point till that passed. I've been trying my hardest to get everything back together. I got 2 full-time jobs. I got my place paid off. I'm up. All my back due rent is paid. I'm doing everything and anything I possibly can. Like within this week, I'm trying to go get enrolled in those inpatient programs because I know I still need to complete that, or the outpatient program for you. So this is not for lack of trying or not wanting to try, but like I said, at this point, moving forward, I'm doing the best that I possibly can with my situation. I have put myself in a better mind space, in a better place. I was more worried about what everybody else had going on besides myself. I was putting everybody else first and not even thinking about myself in the end, in what it was going to cause to, what was going to happen to me. So, like I said, now I feel like I have set myself up successfully to be able to go forward and continue and finish his probation.
Slow down 1 second.
Yeah.
Sergeant, where was he? Where was he pulled over last night or picked up, or when was he picked up? Was it this morning or last night?
It was last night. Brownstone Police Department stopped him for a traffic offense. We picked him up on his warrant, Your Honor.
I love how you're sounding like you've seen the light. You've seen the light now, and you weren't coming in here. You got arrested and picked up because of a traffic violation, and and I know that's the only reason you're here.
I swear, Your Honor.
When
If
were you
my
going to come
mother
in
and my
today?
father were here, they would vouch for me as well. I swear on my life, Your Honor.
You were coming in today or tomorrow? I've heard that story multiple times too.
Within the next. I did not want to come in front of you until I had everything lined out to where it looked to you like I am actually putting in forth an effort. That's God's honest truth. I did not want to come in there.
Slow down. Can I see the screenings? Your name, please.
It's my class picture.
Can I see the I'm hoping this is gonna tell me you don't have any prior convictions. But it's not gonna tell me that, is it?
No, sir.
Why did I know it wasn't gonna tell me that?
And again, also last night, I was on my way home from work. I was a quarter mile away from my parents' house. That's exactly where I was going when I got pulled over.
You haven't shown up on this case on multiple occasions. What do you think? Anything?
Your Honor, I'm looking at, this is an old case, that, Mr. Sino had supervised.
Yeah, it was an offense date of October of 24.
Yeah, and it looks like that she tried to communicate with him in September of 25, then issued the show cause arraignment. Looks like she gave him an effort to show sobriety, sending him to a one-time test. I don't have any proof of treatment, economic crime program. Obviously being called in a warrant, I'm not sure if he has those warrants out of 36 and 19 still today. The only thing that I would have to go back in my office to verify, Your Honor, was he was scheduled for the court work program after this show cause arraignment. I am making the assumption he did not go, but again, I'd have to go look at those sign-in sheets. He was scheduled for October 11, 25, and November 8.
Heather.
And I did those.
Mr. Mitchell, the call of, how much does he owe right now? Anything?
There is a balance of $804.
20?
804.
804, I'm sorry.
And that's what I wanted. I was gonna bring that in with me within the next week as well, correct? I have that, I can have that money, not even a week from now.
Your record's bad. You've ignored courts. You've done nothing. I started this on, I sentenced you on June the 26th. Mr. Westmoreland, anything else?
Yes, Your Honor, it sounds like he's got his life on track. Like he indicated, he is working 2 full-time jobs. He's remained out of trouble. But he does have quite a bit of things that he does need to do, and I would just ask for the opportunity to allow him to continue probation and get everything behind him.
Do anything, right?
Not that I can see, Your Honor. Again, I would like to check on those work days if there's gonna be credit. But there is no proof of any progress on the file when it comes to treatment, economic crime program, his testing, so forth and so on.
I did the court work programs. I did do the court work programs.
Can you check that?
I can check that, Your Honor. I'll be right back.
Yep, and as far as anything else going forward, treatment, I am literally currently in the process of getting all of that going. I just started my new job and they're trying to work with my schedule as far as all of this, but that's the other thing. In the past, I was trying to do it and nobody was working with me. You know, I tell them I need a day off for court and or anything, and they'll be like, oh, you're missing too much work. We can't keep you here.
I'm not one of those that enjoys absconders.
I know
think
that
this
too.
is
I know that,
extremely disrespectful that you didn't come in here and it took an arrest or a traffic stop by Brownstown to get you over here. You were supposed to be, sir, you keep interrupting me.
I'm sorry.
You were supposed to be here 6 months ago. I'm not buying this that you were going to surrender the court. I'm not buying this that you were going to get into treatment. You had since June 26th of last year. We're into April starting tomorrow. That's 9 months. You've got a bad record. You don't take care of business. You didn't show up on this case in the beginning. How many court work program days did you do?
I did. I had 3 of them and I did 2 and I showed up for the 3rd one, but I was 5 minutes late, so they wouldn't let me complete it. I have no problem finishing the rest of this, all of these recommendations going forward. I have no problem doing that. And again, I feel like now I'm way better set up to be able to do this now than I was in the past. And again, in the past, I'm not making any excuse for running and not doing anything, but that's just the way it was.
He says he did 2 court work programs.
He did 2, Your Honor, that is correct, 2 out of the 3.
Probation's revoked. You're to pay costs of $800 and serve 90 days, credit 3. I'll give you credit for last night, credit for those 2 for 87 days. If you pay costs of $800, I'll suspend 62 of the 87 and you'll only have to serve 25. That's more than fair. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. I wish you well. If you can pay the 800, you'll be out in 25 days. If not, you're going to serve 87. Any questions, sir?
No, sir.
Good luck to you. Thank you.
Thank
Thanks, Sergeant. Thank you, Mr. Westmoreland. Guy Neely. People against Janaya Amani Ariane Guy Neely, 25W839-829A.
Everyone name's got Ms. Neely.
Your name, ma'am?
And I am, you know,
Just put on her.
I arraigned her. I entered a not guilty plea for purposes of arraignment. How does she wish to proceed?
I think these have been sorted into 23 violations.
Right.
It's being guilty to all the violations we discussed the right now.
So you understand your probation could be revoked. You could be incarcerated for 93 days. True?
yes,
Did you sign, read, and understand the advice of rights?
yes,
You plead guilty. You'll be giving up all those rights. And we are not going to have a trial of any kind. You understand that?
yes.
All right. That's the count 1 that you failed to attend the court work program on February 21 of 26. How do you plead?
Yeah.
You failed to attend the court work program on that date.
Yes.
Did you fail to attend the court work program on that date of February 21 of 26?
Yes.
Count 2 that you failed to enroll in weekly testing on February 11th. How do you plead?
Yes.
Count 3, you failed to enroll in weekly testing on February 16 of 26. How do you plead?
Yes.
You failed to enroll in testing on those 2 days.
Yes.
Now, count 4 through 23, all allege failure to submit to SoberLink blows. I've already arraigned her. I'm just going to go ahead and ask, ma'am, did you fail to submit to SoberLink blows pertaining to count 4 on February 4 of 26, on March 4 of 26?
Yes.
So how do you plead to that charge?
Yes.
Count 5, that you failed to submit the blows as ordered on March the 5 of 26. How do you plead?
Yes.
Count 6, that you failed to submit to SoberLink blows on March the 6th. How do you plead?
Yes.
Count 7, that you failed to submit to SoberLink blows on March the 8th. How do you plead? Count 9, that you failed to submit to SoberLink blows on March the 9th of 26. How do you plead?
Yes.
Count 10, that you failed to submit to SoberLink blows on March the 12th of 26. How do you plead? Count 10, that you failed to submit to SoberLink blows on March the 13th. How do you plead?
Yes.
Count 11, that you failed to submit to SoberLink blows on March the 14th. How do you plead?
Yes.
Count 12, that you failed to submit to SoberLink blows on March the 15th. How do you plead?
Yes.
Count 13, that you failed to submit to SoberLink blows on March the 16th of 26. How do you plead?
Yes.
Count 14, that you failed to submit to SoberLink blows on March the 17th. How do you plead? Count 15, that you failed to submit to SoberLink blows as ordered on March the 18th of 26. How do you plead?
Yes.
Count 16, that you failed to submit to SoberLink blows on March the 19th. How do you plead?
Yes.
Count 17, you failed to submit the blows on March the 20th. How do you plead?
Yes.
Count 18, you failed to submit the blows on March the 22nd, 26. How do you plead?
Yes.
Count 19, you failed to submit the blows on March the 23rd of 26. How do you plead?
Yes.
Count 20, that you failed to submit the blows on March the 24th of 26. How do you plead? Count 21, that you failed to submit the blows on March the 25th of 26. How do you plead?
Yes.
And count 22, that you failed to submit the blows on March the 27th of 26. How do you plead?
Yes.
Count 23, you failed to submit the blows on March the 29th. How do you plead? Did you fail to submit to SoberLink blows on March 4th, 5th, 6th, 8th, 9th, 12th, 13th, 14th, 15th, 16th, 17th, 18th, 19th, 20, 22, 23, 24, 25, 27, and 29?
Yes,
Anybody force you to plead guilty?
no,
Why? What's going on?
Judge, clearly, she's off to a poor start on probation. Ms. Lagat.
Who's this with you? Holy.
We came up with the same potential solution in the time of leave that, maybe a tether would be a good idea.
Can I see the screen? Do you work?
yes,
Where?
yes.
What do you do there? Listen, I'm not boring you, am I? What are you yawning like that for? Are you tired? I'm asking you a question.
No,
Well, why are you yawning if you're not tired and I'm not boring you?
it's okay.
Did you take care of this ticket out of 25th District Court for driving under the influence?
No, I took, care of Taylor and
Why
one.
don't you go over to the 25th District Court and take care of that?
I was waiting on my check.
How immature are you?
Huh?
How immature are you?
I'm very sure.
Who are you living with?
I live with my sister. I live with two people, my mom and sister.
How long you been working at DMC?
Just started. I was, in school.
Where were you going to school at?
Providing career training in your.
Did you graduate?
Yeah.
You said phlebotomy training?
Yes. Providing was a scam.
Well, I only sentenced you February 4th. This is reports as a student, no income, $200 a month of bridge card benefits, single, no children. Graduated high school in 19. I ordered you to clear all your warrants by March 1. You didn't do that. You got a big problem here, and I'm trying to figure out how I can do to save you. You cannot do this. You can't just ignore courts like this. I don't know what you're thinking. I mean, you put yourself in a horrible position here. Sir, you got to get her to grow up. Her life's going to be an awful long experience, not a pleasant one. Wow. And you were then the one bawling out here in the courthouse in the hallway?
Yes.
What? Realization that you can't just thumb your nose at a court. Is that what it was?
It's no, so I look, I'm scared. Still like this, I'm not really a bad person. I don't have a problem with doing it, but when it's just got my time, right? I'm really fast, so the time it just a lot in my head. And I get thrown off because I'll be doing one specific thing I know. So it just be a lot. And then I'm like lifting gear, plus therapies. It's like all this is taking my money for me to even eat or have stuff to kind of like be able to handle my business. It's just a lot. It is a lot. I'm young, I'm not 24, I don't have no kids. So I'm trying to do the best I can by giving all my money away and stuff like that. Like paying these tickets. It's just, it is a lot. It's making me forget things and stuff.
You didn't go over to the 25th, like I told you, by March 1, surrender on the warrant. I'm not excited about that. That was an OUIL. It's an OWI. I don't know what you're thinking. I really don't. I mean, I'm finding this one hard to believe. You did nothing. 23 counts of a probation violation I could count on one finger probably the number of times I've gone to 23 counts on a probation violation. I'm serious. I mean, I'm not sure you've left me with any choice here. And the choice that you have left me with is not one that you're going to want. I don't know what to say. Can you give something positive to me?
She is enrolled at the guidance center. She's going twice weekly, once for individual therapy, once for group sessions. She did get enrolled in that beginning, about the middle of the month in March. I was told about that. Again, I don't understand that it's a lot of stuff all at first, but when she was sentenced, I went over everything with her. I gave her all the paperwork. I then sent her an email that has all of her stuff listed out for her. When she missed testing the first time, she did call me on an unrelated matter, and I gave her the opportunity to go again on the 16th for testing to make up for that miss. She still didn't go, didn't reach out to me.
She's still drinking and or drugged.
That's it. I can't prove it.
There's no, you can't convince me otherwise.
I'm not saying, I don't have a problem. That's not the issue. It's just I don't have no ride, sir. I don't have no ride. I'm using my lift.
You had a sober link device that should be right with you at all times.
I'm
Well, why did you have to get a ride to go take the sober link? You've missed all these tests. You've missed somewhere in the neighborhood of 60 or 70 tests.
The problem is I'm just not blowing at the correct time you guys had. Like you had me blow 7 a.m. I'm already at work. You know what I'm saying? So it's like
we talked about changing her testing time and she was sent.
That's just the problem. I'm blowing. It's just not the right time.
All right.
Judge, there are times where she is late on the blows, but I didn't even include all the late ones. I just included the ones that she missed completely or was over 3 hours late on.
Well, you got 23 technical violations here, okay? Now, you cannot do this. You cannot do this.
Judge, if I could.
Yep.
If she's to remain on probation, my recommendation moving forward is that she have a scram together.
Oh, yeah, I know. I'm already writing that down. I'm not gonna assess any costs. I'm gonna give you a break. But it's not gonna be a break that you're gonna like. We're gonna, SoberLink is to be replaced with a scram when she's released from jail. 8 days jail, should be 80. So don't be complaining or crying about it on your way out of here. Do we understand one another? 8 days. That is a Christmas gift in March. Good luck. You no cost. And then you're gonna coordinate getting the scram off or the SoberLink for the scram, right? Thank you. Do I have anything else this morning, John?
No, we do have an unidentified phone number out here and I can't chat with a phone
Here's on
number.
the 515-705-442-012, it looks like. Can you tell us your name, please? You're gonna have to have a seat in the jury box, man. You gotta grow up, young lady. I'm giving you a chance now. You better follow through. Who is that on the phone there, ma'am or sir?
Hit *6 to unmute, please.
Okay.
15705-442-012. We need you to unmute and state your name, please. Ma'am, come on now. You were given a massive break.
Hey, excuse me,
Yeah,
Your Honor.
What's your name?
Duante Borgnite.
He's he's an 11 o'clock arraignment for a felony. I'm not sure why he is on Zoom.
I'm in prison.
Oh, okay.
Do you have a case with me?
Yeah.
Yeah, he's an 11 o'clock arraignment, felony arraignment with us.
We don't have a file.
Has he talked to a lawyer yet?
No, sir.
What?
Well, wait a minute. Are you in jail or not?
Yes, sir. He's in jail currently. He's housed at a Federal Correctional Institution, Schuylkill in Minersville, Pennsylvania. I'm his case manager for Ryan Pramba.
Well, can we have him start the video, please? I can't arraign him if I can't see him.
The instructions that we had, we can't connect with a Zoom crc.com account. So in the instructions, it said that we can call. That's why I had him place a phone call rather than the hearing.
I didn't send this one, Judge, but there was no SIP address given to you guys?
The SIP address, yes, it was, but a zoom.gov account won't connect with a Zoom crc.com account. That's what my computer services technical center advised me of.
That's the first time we've had an issue. That's weird.
Can you work that out, Heather, with Lisa or yourself?
That's what we normally, that's what we used last time we connected with the federal prison and we had no issue with the SIP address.
Is this an arraignment on a felony out of Flat Rock?
No, he's a state, it's a state case, Judge.
Okay, but where's it out of?
Let me.
Do we have the file down here?
I think it's out of Woodhaven.
I know that. Give me a second, sir.
I don't, the file should, I believe, was in the docket. It was on the docket. I didn't add this one. Let me take a look at mine down here. Yes, it was. Yeah, it should have been in our docket down there.
So this felony,
You didn't start, yeah.
this isn't even a, oh, yes, it is.
What I thought of. Hang on.
So we set this arraignment up for today. This is. This is out of Flat Rock. This was from 22. So I guess we got to get Westmoreland to talk to him. And I don't really need Flat Rock on this. So can you set up Miss Westmoreland, Heather, with the defendant? Let them talk.
I'll get them in a breakout room.
Right. And then everybody can let me know when they're ready.
Okay, sounds good. So,
I don't
Mr.
need anybody from
Baltnight,
Flat Rock on that
I'm gonna
charge.
put you in a breakout room. And
Yes,
then more
ma'am.
than like, when you guys come out, you're gonna have to disconnect and then call back in to come out of the breakout room, okay? When you're done speaking with the attorney.
So we'll have to call back into this.
Yeah, usually to come out of the breakout room when you're on a phone number makes you come back in normally.
And are we gonna have to unmute ourselves when we come back in?
Go tell her.
No, I
if
just
she
muted you guys
continues
because
to
he was on
scream,
the
I'm gonna
bench.
bring her out here and she's not gonna like what's gonna happen next.
So when you
Thanks.
guys sign back, no, when you guys sign back in next, I won't mute you, okay?
Thanks, Heather.
Okay.
No problem, good. Sadie, is that file going over to Corey?
I can take it to him.
Thank you.
Yep.
Large bump bruise on her forehead and likely a broken nose due to this case, so I'm gonna be checked.
You said there was a prior deferred. Anything else?
No, Your Honor.
Motion for bond reduction or modification is denied. Bond will, all its conditions.
Right.
Being unable to proceed, this case is dismissed on defendant's motion. That's without prejudice. Thank you.
Thank you.
This is it. Or, yeah, I've lost.
You'll be home.
Yeah, see if we can find him. I'm ready. That's all I got now. Here we go. Sheriff. Exhibit.
It's driving me crazy. Oh, right.
So everybody just left. Thank you. Appreciate it. Where'd they? Yep. Okay.
Bigger now.
Yeah.
Well, I can't, I know, but I keep losing more people. I send them, okay, there's him. Where's Ian? Okay. You got a call.
Yes, sir.
I'm great. Thank you for asking. No. Fill my water? That is very good. No, it's great water. Did a wonderful job. I'm proud of you. No, that's perfect. I know. I see that. Then, you know. Yeah. You need to quit messing with me. Court does call the case of the people of the state of Michigan versus Ronald Savoy Fleming.
Morning, Your Honor. Ashley Lonnie Feltus for the people.
Good morning, man. Please start with Court Rick Johnson on behalf of Mr. Fleming. Approach and seat to my right.
In your name, sir? Thank you.
Your Honor, we are set this morning for a preliminary examination. It is my understanding after talking with Mr. Johnson that we are proceeding to a preliminary examination. People anticipate calling 4 witnesses, and I have a copy of the revised postmortem examination report that I am admitting pursuant to statute with no objection from defense counsel, if I may approach with exhibit 1.
Yes. Is that all correct, Mr. Johnson?
Yes, Your Honor.
Exhibit 1 is admitted.
And I have 4 witnesses: Ronald Fleming, who is not the defendant, born a different year, Detective Thomas Robb, Detective Aaron Seyring, and Detective Heather Morrison. Detective Morrison is remaining he is my officer in charge.
That's fine. All right. You may call your first witness.
Did the court admit exhibit 1? I apologize.
I did.
Thank you very much.
Hours ago.
I guess people would call Ronald Fleming for 1971.
Sir, please come forward to be sworn.
Ryan C. Cheatham versus the Kansas Department of Corrections, case number 2025 CV 294. Corrections, case number 2025 CV 294. Elizabeth Fowler appears representing the Department of Corrections. Joshua Andrews appears representing the petitioning inmate in this case. Ryan C. Cheatham versus the Kansas Department of Corrections, case number 2025 CV 294. Elizabeth Fowler. All right, again, Ryan Cheatham appears as the petitioning inmate.
separately from his lawyer by Zoom. This matter comes before the court at this time for further proceedings. There was an earlier proceeding in the case where the court recessed to allow the attorneys to research an issue that arose regarding a possible liberty interest suffered by the inmate in this case for alleged loss of accrued good time credit. The court has looked at the file and it doesn't appear that there was any documents that verified that he lost accrued good time credit. But I'll ask Ms. Fowler, did your research or further checking indicate that he did suffer that penalty?
Your Honor, as I filed with the court and made available to my opposing counsel, I filed what was marked as Exhibit H, which is good time award record for Mr. Cheatham for the time period in question. There were 4 DRs that Mr. Cheatham received convictions for during that relevant time period, including the DR which he appeals, the battery DR. The document reflects that he had good time withheld. So he did not earn any good time for that period in question, but that no good time was forfeited. And I did provide that to opposing counsel shortly after our last hearing.
Your Honor, may I address the court real quick before we proceed?
Just a moment.
Because
okay, go ahead. Go ahead.
I'm choosing because I was on mute, but I'm choosing to invoke my right to represent myself because, like I said, I'm not a lawyer, but I, you know what I'm saying, comprehend the law. I feel like a little bit good. And the liberty interest that I feel like is at hand, it refers to the Wolf versus McDonald, and it's about the due process procedures in a disciplinary hearing, the impartialness of the hearing. Also, you know what I'm saying, I would like to address the good time credit too that she's talking about, because the document it's extrinsic. It's an extrinsic piece of evidence, and I feel like I got another form that shows 133 days available versus 0 days, and then the document that they provided to the court states 23 days. You know what I mean? So I've read a case law that says that we can't challenge the fact that with unearned good time, it's not a liberty interest. Good time that's withheld is not a liberty interest because one hasn't earned it yet. Well, I feel like the document, you know what I'm saying? I feel like we need to have an evidentiary hearing or be able to prove like, or direct the courts to direct KDOC to show the good time that I did have in the bank that was available, and whether or not it was subtracted, the 23 days was subtracted from that, because I feel like that document that was provided only shows the 23 days that were available. And it's saying that, you know what I'm saying? I feel like it's not, it's ambiguous and it's vague, sir, you know? And I also want to address the fact that there was insufficient evidence to convict.
Okay, Mr. Cheatham, I'm just going to put a hold on things for a moment.
Go ahead.
I was going to address your attorney regarding the liberty interest regarding accrued good time credit. Mr. Andrews, did you have any additional remarks to add to Ms. Fowler's?
Your Honor, in light of my client, he had let me know before court that he was desiring to represent himself going forward. So I was going to ask the court to, I think he has the right to represent himself on these proceedings. I was going to ask the court to allow him to represent himself going forward and propose that I remain on the hearing as standby counsel, but that, regarding any substantive comments on the issue that Mr. Cheatham's requesting to represent himself on that.
All right. And given that statement, Mr. Cheatham, are you indeed wanting no assistance from legal counsel in this case, and instead you want to represent yourself in this disciplinary hearing matter?
I mean, it's like, I feel like my argument, you know what I'm saying, with the liberty interest is being swayed.
That's a yes or a no, really.
Yeah. I'm wishing to invoke my right to represent myself. Yes, sir.
All right. Stay on the meeting, muted. Mr. Andrews as standby counsel. All right. Mr. Cheatham, you're trying to cover a lot of ground really, really quickly. I'm going to go back to Ms. Fowler for a moment. He seems to suggest that somehow the records don't reflect that he didn't lose accrued good time credit. Do your records know what he had earned as of the date of the offense in this case?
Your Honor, I don't have a accounting of all of his hours, but before we even get to that, Your Honor, I would say first of all, his petition in this instance didn't mention good time at all. This is an issue that came up later after he reviewed my brief in which I said he had no liberty or property interest. And then he's since then inserted this good time argument. I don't think that's proper, but I did accommodate, provided the record. Now he's asking for additional records, but Your Honor, the burden is his. It's not mine to prove that we didn't take any of his good time. He didn't assert it in his petition. I produced what we have related to the good time record for that time period. He hasn't asserted any property or liberty interest that would invoke his right to those due process protections as he's indicated that he was denied during this hearing.
I did state that I wasn't able to call witnesses, and I also stated that I was never afforded the appeal or whatever as far as on remand of the record, the clarification of the record. So I did state liberty interest, and I'm looking at Wolf versus McDonald's, and it says that I have a right to prepare a defense. I have a right to call witnesses on my behalf, and I wasn't afforded that opportunity to do that.
And Your Honor, the case law is that he has to prove that he had a liberty or property interest.
Right.
And
so the liberty.
Okay, Cheatham, hang on just a second.
Go ahead. Yes,
I
sir.
do want to refer to the Secretary of Corrections ruling in this case as part of the exhaustion of administrative remedies. The sanctions that are referred to on the back of that document indicates 15 days disciplinary segregation. And that's
right. So the issue was, remember, I said that I lost good time that the unit team took. The disciplinary hearing officer didn't take good time, but the unit teams did. So that's why we recessed, so that we would be able to provide to the courts the documentation on where I lost good time at. So the good time, the exhibit that Ms. Fowler submitted to the courts, I'm saying that it's vague and ambiguous, sir, because it doesn't show. It doesn't show what I lost in the bank. It doesn't show. It only shows a summary of something. And in my opinion, in my position, it's extrinsic. We shouldn't rely on that. We should.
well, then what would you rely on?
I would rely on. No, absolutely not, sir. I would rely on either evidence we're hearing so that the unit teams can testify to exactly what was lost of good time. But to rely on a paper that I have that's contrary to her document, one says 23 days, my document says 133 days. So which one do we go with? Which one, you know what I'm saying, is proper?
Did you even raise this claim in your petition?
I mean,
corpus relief,
but you chose to entertain it though. We recessed to entertain it, and now I want to further entertain it, but I also want to address the fact that I wasn't given a fair partial hearing.
Okay.
I mean, I just want to make sure that that all the rights are afforded to me, because like I said, according to Wolf, it's saying that, you know, that we're entitled to a impartial hearing, and my hearing wasn't impartial because I didn't swear in and raise my. So not only was I able not to provide a defense, which it says I'm allowed to, and if staff assistance was appointed, I was supposed to be able to direct and guide that staff assistance, which I didn't. And then the sufficiency of the evidence, you know what I'm saying, that how they convicted me, it was a short statement. An adequate statement of reason must be based, point out the essential facts upon interference were based. You know what I'm saying? And it was the record, due to the preponderance of evidence, it was found guilty. But Secretary of Corrections remanded it for clarification of the record because they wanted to know specifically by the reporting officer whether or not I made physical contact in an assaulting manner. And this decision to uphold wasn't until 9 months later. And I wasn't a part of that second process, which I also have a right to be present at every stage of the disciplinary hearing. So, you know what I'm saying? So for us to just focus on the good time, I feel like is an attempt to sway an argument that we already know is going to get denied anyway. So that's why I chose to represent myself, because like I said, I don't want to get taken advantage of because I don't have the degree as Mr. Andrews. So if I'm wrong about what I'm saying, you can let me know, and I guess my remedy would be to appeal.
All right. Mr. Cheatham, I don't have any record in this entire file that indicates that you lost already earned good time credit.
Right.
The Department of Corrections record should reflect if that was part of this disciplinary proceeding or not. And clearly, it indicates that the sanction that was imposed is 15 days of disciplinary segregation only. So I think Ms. Fowler's point is well taken. There
Right.
was no
So
loss
okay,
of a property interest or a liberty interest under those circumstances.
What
You can not do is interrupt me when I'm talking.
Right, but you knew that our last court day, sir. So why would you recess it for us to be able to provide further documentation? And when her documentation provided to the court is vague, now you want to go back to the DR initial that I received 15 days disseg to substantiate and deny my petition. So basically, you're not going to afford me an opportunity to combat her document, is what you're saying. So why did we recess it in the first place?
To have her look into it further, which he has done.
And I got a document that contradicts her document, and I'm trying to provide that to the courts. So how are we going to go about that? Her document doesn't show 133 days.
And it shows as part of your disciplinary proceeding that you incurred a loss of accrued good time credit. Is that what your document shows?
Yes, sir. It shows that there was more good time available other than 23 days. So what I'm saying is the documents that we
Mr.
should
Cheatham,
either have.
let me ask you this.
Go
Let me
ahead,
ask you
go ahead,
this.
sir.
You've
Go ahead.
had
No,
multiple disciplinary proceedings, haven't you? Are you sure that if there was an adjustment of your good time credit, it wasn't connected with one of these other disciplinary cases?
No, I'm saying exactly that. I'm saying I want to have an evidentiary, sir, so that we can have the unit team managers come and provide either testimony or further documents, because I can send this over to the courts. I don't know if you can see this right now, but the document that you're looking at, it shows hold on.
Okay, I really can't see it. It's just all blurry.
Okay, you see where it says hold on, why it's being blurred out. Why is it? You see that word? Yes. Are you blurring it out or what? Well, it says 100. Okay, so
document he's holding up.
It's the same one, sir, that she has, and it shows 23 days versus mine says 133 days. So my argument would be that this is an extrinsic document, and we have to further investigate the actual good time that was taken from me, because this paper shows the 23 days outside the Senate bill. It shows more than 23 days. You see what I'm saying? Like the document,
I really don't.
The document that's in front of you, sir, it shows available good time credits for award period. It says 23 days. My document says 133 days. And then it says good time credits awarded. It says 133 days. So what I'm trying to say is this paper that we're relying on to see what was available and what was not, what was forfeited and what was not, and what was withheld and what was not, to establish a liberty interest is vague and ambiguous. And I'm asking the court to allow an evidentiary hearing so that the unit teams may present further evidence. And I feel like I deserve that.
To allow that, Mr. Cheatham, I would have to be convinced that the records from the Department of Corrections are incorrect, that you actually sustained the loss of accrued good time credits as a part of this disciplinary conviction. This is not a proceeding to determine what good time credits you're entitled to as a prison inmate.
Right, I'm not saying that,
Generally
sir. I agree exactly what you're saying. I know what you're trying to say, and I just wanted the opportunity to show that I lost good time. I lost 23 days of good time. And I
wanted 23 days withheld, Your Honor. He had them withheld. They weren't forfeited. He didn't earn them.
So let me just say this real quick. The unit teams can only take good time you've already earned. They can't take good time that's not in the bank. The disciplinary action can take up more than 6 months, but the unit team is only allowed to take what you have already in the bank, Your Honor. So that's what I want to be able to cross-examine and to have the unit teams testify to. So let's just say this: if you pay me for working for you, sir, and I got money in the bank from working for you, right? So the unit team is able to take from that money that exists in the bank. They're not able to take away from next month's paycheck. You know what I mean? So that's what I want to establish, that I lost good time that I had in the bank, not future good time.
All right. I don't have the document before me that Ms. Fowler has. I don't at the moment. When was your additional
Honor.
exhibit submitted to the court?
It was filed into the record yesterday, exhibits H and I.
All right.
And if I should do that differently next time, Your Honor, I wasn't sure how best to provide those documents. And like I said, I did provide those to opposing counsel, and I did provide our good time record shortly after our last hearing. And I didn't receive any additional documentation from Mr. Cheatham.
All right.
I notified.
Those exhibits are pertinent to our discussion, so I'm going to recess briefly and access those two exhibits.
Sir, this exhibit I found yesterday, and I tried when Mr. Andrews.
The court will recess briefly.
Yeah. You know it. I done beat 3 trials last 7 years doing what I'm doing. Hey, Crawford.
H and exhibit versus KD. This time the court will resume the record in the Cheatham versus KDOC matter. All persons appearing as before, the court has now had an opportunity to review the very recently filed documents, Exhibit H and Exhibit I. All right, Mr. Cheatham, you're muted.
There you go. All right. Can you hear me?
Yes, I have before me a good time award record from Larded State Correctional Facility. The award date is stated at 12/11/2024 up in the corner. Is that the document you have?
No, sir. The document I have says the same similar good time award credit. And then it says from a period of 2024 through 2022, and it says 133 instead of 24.
Okay, this is dealing only with the award period from August 18, 2024 to December 18 of 2024, which was apparently while this disciplinary matter was pending.
Right.
Yours is apparently for the period before that.
Okay, so right, I get that part, right? But it's saying that so I guess according to the Senate bill, it says that because of my crime, I'm only allowed either 21 days or 23 days per period. But it's like that only shows, it doesn't show what was taken out of that bank, that what my argument is, sir. I'm saying from my understanding, I just asked my unit team this question. I said, is it not my, because if I'm wrong, sir, I'm wrong. I'll kick rocks, you know what I'm saying? But what I'm saying is the good time that I've already earned that was in the bank, I'm trying to figure out how can we show that it was deducted from that, because that paper just shows the 23 days in you know what I'm saying, what was withheld in this and that. My other argument, you know what I mean, I don't know if you're going to entertain it or not, because this is why I chose to represent myself, because me and Mr. Andrews was kind of at odds with it. It's like, I feel like the Supreme Court, you know, and I'm not asking you to overthrow them, and I know you're not going to. So my thing is, our Casper website pages show an early projected release date, and it shows a later projected release date. So like, according to Casper, we already earned the good time. We already got it. We just have to demonstrate good behavior. And if we don't, it chips away and it goes to the later. It doesn't go from the later to earning the good time to the earliest possible. So I feel like, okay, from a business aspect, if the bank account has money in there and you know what I'm saying, on paper it says, hey, Mr. Cheatham's already got this money in the bank because he's already earned his good time. All he has to do is show up to work. And if he works, then the books are cleared. You know what I'm saying? So it's like, I'm not trying to overthrow the Supreme Court, but that's why I didn't want to focus on that. And I'm like, well, hey, how do we not know from what the unit team manager is just telling me? They're saying I can only take away what you earned. I can't take away what you didn't earn. You know what I'm saying? So that's why I'm like, why should we only rely on the good time paper when we can have these unit team officers come and testify as to their duties and how they go about deducting good time?
So I should rely on your hearsay statements regarding stuff that you say have been told to you by unit team members rather than the actual documents that the Department of Corrections maintains?
No, sir, I'm not asking you to
Well,
rely.
okay.
I'm not asking you to rely
Well,
on
I think I'm
hearsay
prepared to
because
rule. Mr. Cheatham, the documentation that's been provided by Ms. Fowler at the suggestion of the court indicates that you did have good time credits withheld during this pending disciplinary matter of 23 days. It clearly shows that you were not awarded those 23 days that you might have earned, but for the disciplinary conviction. But it doesn't show in any way, nor is there anything in this entire thick file that would indicate that as part of your disciplinary sanctions, you received a loss of accrued good time credits. In fact, the Department of Corrections has demonstrated to the court documents which indicate the concern the court had the last time we were in court. I think they've shown that you lost non-earned credits.
All right, I will not dispute that. So is that the only liberty interest that I can argue, or is that what about the
That's
witness?
the only one that has been suggested to the court.
Okay, exactly.
In fact, I'm not even sure you raised that issue in your petition.
Right. So now we're getting somewhere. So now this is why I said for us to argue that, and I didn't argue it. It was only meant to deny my petition. That's why I was opposed to arguing in the first place. What I did argue in my petition and cited was the fact that I wasn't afforded to call witnesses, sir.
But you only reached those hearing defects, according to you, if you can show that there was a legitimate property or liberty interest triggered.
So the liberty
you
interest,
did not get fined. You did not lose any financial matters at all. So there was no property interest triggered here. And the liberty interest would have been theoretically from the loss of accrued good time credits, which I think the Department of Corrections has shown didn't happen here. In fact, numerous documents would seem to indicate otherwise. So the court's going to find that we're not going to reach the issues of due process as there was no legitimate property or liberty interest triggered by the disciplinary sanctions imposed in this case. I'll also just note for the record that there appears to have been some evidence to support the hearing officer's decision. And that's a relatively low standard, and it was certainly met in the view of the court upon review of the file.
Can we elaborate on that, or we just
no?
Right,
No.
exactly.
That's an observation that the court has made.
Yeah, what observation? Just like you said that you observed her document and you recessed it to get it. Come on, man. All right. So
Mr. Cheatham, I'm going to find in this case that the disciplinary sanctions in this case did not involve a protected liberty or property interest in this case.
No, and I want to
put
this on. I just want to put this on.
Corpus
is denied.
Should not be furthered.
Right. And I just want to put this on record for appealing purposes. I did not argue the fact that good time credit was forfeited. This was erroneously projected to the court and presented to the court only to deny my petition, as stated by Judge and Ms. Fowler, that it was not even cited in my petition. So
right.
So why
you didn't raise the issue of a protected liberty interest even in your petition, Mr. Cheatham? You argue it now so that the court.
I didn't argue that. That's what Mr. Andrews wanted to argue.
All right.
Y'all have a good day, man. God bless, man.
Okay. The writ is dissolved and the habeas corpus petition in this case will not be furthered and the case is terminated at this time. At this time, the court is in recess and the court will end the meeting for all.
Please raise your right hand. You solemnly swear to affirm the testimony about to give the truth, the whole truth, and nothing but the truth, so help you God. What I see. State spell your first and last name.
WMING.
Good morning, sir. How do you know Ronald Savoy Fleming? He's your son. Do you see the person you know to be Ronald Savoy Fleming in the courtroom today? Could you tell me where he's sitting and what he's wearing, please?
Next to this person right here, he's looking at the top of the white underneath shirt.
Your Honor, may the record reflect that this witness has identified the defendant?
That objection, record shows so.
Did you know a person named Theodora Fleming? Who was that? Your mother was Theodora Fleming? Do you know what township your mother lived in 2024? Did you have occasion to go to her house on May 17th, 2024? Why did you go to her house on that date?
Phone call from my house. Notifying mother. You failed to check in, mother, sisters, they would text each other every morning, group of life to see if they're still around.
Well, how old was your mother at that point in 2024?
73.
73.
Just turns.
And after you had heard from your aunts that they hadn't heard from your mother, what did you decide to do?
Initially, I was going to go out, and come out, they my informing me that my son was kind of unaware. I changed over, coming to the morning, calling.
And where do you live at? What city? And where is that?
My house, more than see if I
So a little bit of a drive to come up to Ypsilanti Township. Did you arrive at the house on May the 17th, 2024? How'd you get there? Where did you park when you got there? What did you notice about the house when you drove up to it?
They popped out all the windows, the sheets on the windows were shed.
Why did that pop out to you?
I had the last, I've ever seen. Fully cut all the sheets. Never seen.
Was that something your mother would routinely do?
I never seen it. Oh,
Would always have them open? Did you notice anything else about the house?
essentially, no. When I got out, knock on the doors, I noticed that both screen doors were on from the inside, which is normal. But with the shades closed and then it's just something it's just way out of the order.
Did you notice any sounds coming from the house? Did you go up to the doors or windows and try to knock on them or see what was going on?
Front door, that's long shut on the screen. Went to the side door, realized the door, the screen door locks, there's no access to the door. So I went back to the front of the house, just have those up just to see if I could get a response from the dog.
What kind of dog was it? Bull Mastiff. Was it a big dog? Did you hear any response from the dog?
Once I tapped on the window, the dog would jump up and brushed it against the long vertical line. So I just kept tapping on the window just to see what was going on. What could I see? Fiction. And the first thing I noticed was involving the dog water bucket was full. I just told someone was in the house without answering the door.
Judge speculation. Sustained.
When you saw that the dog, when you heard the dog, you said you noticed the water bucket was full. Did you contact the police?
First, I called the police. Before I called, I just walk around. And follow you. I was just really checking. Oh, but with the dog. As soon as I saw that, I stepped off the porch. A little bit into work yard. Please. That's called
What was your aunt's name?
Mary.
Did she have a key to your mother's home? Did she give that to the police officers? Do you remember the address where your mother lived?
15 Warrant.
That's in Ypsilanti Township, Washtenaw County. Now, eventually the police came to the home, right? Did your son ever exit that home? Did he exit the home after the police got there? When did he come out of the home?
First thing, police officer showed he saw the dog, so he called the Washington County. He makes his hey, I can't show and the dog enter. They proceeded to enter the house, but breaking kind of safety seal, breaking the locks of the screen door. Used the key to open up the door. Just initially, dog catcher secured the dog. Police officer.
And you had asked the police officer who came to help you out with finding your mom, right? You would ask that deputy that came to the house to help you? You were worried about your mother? After the dog was secured, did that deputy go inside the home? At some point after he went in the home, did the deputy and your son come outside?
Once the deputy went in, seconds later, I and mom to assist from the house.
Did he ask you to step outside? At some point, did you see your son? Was there anything about his behavior that concerned you?
Not until we walked out the house. That's when I really started paying close.
What did you notice?
Shocked that I was there. Reactions and utter shock. Objection, foundation, speculation.
If you want to ask questions, I wouldn't allow the answer, but
Thank you. You've known your son his whole life, correct, sir? You're familiar with him? You're familiar with how he portrays his emotions on his face? And in this situation, had you seen emotions like shock before on his face?
It's more so surprise than someone. Good way to say it. I don't think he anticipated.
Now,
so that the record's clear, I'm going to overrule the objection with that foundation. I'm going to allow the answer. Go.
thank you very much, Your Honor. At some point, while you, your Aunt Tony, the defendant, and the deputy were outside discussing where your mother might be, did you speak to the deputy by yourself?
Not initially. No, initially, no, we were all sitting and just talking. Police officer was asking Ron questions. Where could possibly be? What was her phone? And we all reaching out, looking for her. the Coney Island restaurant. She goes to their report every so often. Initially, we thought we were at the county rec center because she's also a swimmer. This officer, he lied. Whatever told us to check and see if there's any ambulance reporting so that she could pick up an ambulance or in the hospital. Check to see if she's in the hospital. And the officer started asking, has she ever walked off?
This one out of judge's hearsay is what the officer asked.
Well,
I'm not offering it for the truth of the matter asserted, Your Honor. I'm offering it to guide the next steps in what this witness did.
I'll overrule the objection. Take it for that purpose.
Thank you, Your Honor. At some point, did the deputy go to his car that was parked out front?
He did, but in fact,
Sure. Skipping ahead a little bit, did you and the deputy have a conversation in the front yard? What, if anything, did you express to him at that time that concerned you?
when we got, let's replay how thing. Again, initially we were asked questions, the police officer asked questions. Wanted me to speak. As long as I heard it, I knew that was a lie. I knew there was something false information, and that's when we went back into the house to gather evidence, whatnot, with timeline. Then the police officer noticed, looked at Ronald, saw his shoes, saw his legs, whatnot, put him in custody. And while we're up in front of him, yes, we did talk. Asked if I saw it, because I asked the officer, how did you look at it? And that's the best one.
So before your son was arrested, did you and the deputy have a conversation in the front yard? Do you recall talking to him at all and expressing your concerns? What were you concerned might have happened?
Initially, we love me past scary or got it. Man, like they got the bail. That was from what? Where is she?
May I have a moment, Your Honor?
Yes.
I'll pass the witness, Your Honor.
All right. Cross examination.
Sir, the truth, when you spoke to the police, you described your relationship with your son as estranged. Sir, I don't answer questions, I ask.
Oh, no, because
Did you understand my question, sir? Okay, now, isn't it true that prior to that day, you hadn't spoken or seen your son in over a year? No further question.
All right. Thank you. Any redirect?
I have no redirect, Your Honor. May this witness be excused so he could witness the rest of the proceedings pursuant to the Victims' Rights Act?
Any objection to that?
No, Your Honor.
All right. You may step down, sir, and you may remain in the courtroom. May call your next witness.
Thomas Robb, Your Honor.
Yes. All right, what the court's gonna do before we call this next, this court's gonna stand in brief recess. All right.
All rise. State spell your first and last name for the record, please.
Heritage Thomas Rob, THOMAS. Rob is RAAB.
Main court.
Thank you. Good morning, sir. How are you employed?
The detective with Washington County Sheriff's Office.
How long have you been a detective with the Washington County Sheriff's Office?
I
Were you employed before that with the Sheriff's Department?
was
In what capacity?
definitely for about 4 years.
Do you have prior law enforcement experience before you came to work for the Washington County Sheriff's Office?
I did police officer, the town of Jackson, like,
Were you working for the Washington County Sheriff's Office on May 17th, 2024? You recall what day of the week that was? Were you dispatched to 1315 South Warner in Ypsilanti Township, Washtenaw County? And why were you sent to that address?
I've been dispatched there for a welfare check, for some family members that called in, stating they requested some assistance checking on a relative.
Had you done a welfare check for an elderly person before? When you arrived at the home, were there any people outside?
Yes, there's.
Did you speak with them? Who did you identify them to?
The male identified as Ronald Fleming. I think he's the son of the elderly woman subject to check, welfare check. The female was a Tony Curry. She is the subject's sister.
Did either of them give you a key to go inside the house? Who were you looking for?
Theodore Fleming.
I'm going to ask you a series of questions to describe the layout of this house. How many doors are there to this home?
On the exterior.
Yes, how many exterior doors?
There's a front door, which is on front of the house, street side. And then there's a side door, which if you're facing the house would be to the left, which is the east.
Is that adjacent to a driveway? Are there any other buildings on this property besides the home?
It's a detached garage and the independent driveway on the east side of the house.
Is that in front of the home or behind where the home is located?
On the inside.
Did you check these doors? Did you check the screen doors? What did you find about the screen doors and the regular doors?
The screen doors and the actual physical door with durable slots.
Did you open the screen doors with something?
Yeah, I asked both Mr. Fleming and Ms. Curry, when informally the screens which were locked, and they asked them if they were fine if I popped the doors with a small try not to cause any damage, just so we could access the interior door to see if the key would open it, which I did.
Did you check any of the windows? What did you notice about the windows?
I remember checking the windows on either side of the front door, as you're facing the front door, the window to the left was unlocked. I was able to slide it open with my hand.
Was it closed at the time that you contacted us? And when you opened the window, did you hear anything?
Yes. Dog barking. So,
What did you do next?
I announced myself. I called out the sheriff's office. The dog was barking. The dog ran up to the windowsill and jumped in. He was trying to bite me, so I closed the window.
Were there any cars in the driveway?
Yes.
Were you able to identify whose cars they were at any point?
Red Jeep SUV that was backed in towards the back of the driveway, which I identified as Theodore Fleming's car. And then there was a black sedan nosed in on the street and driveway. And Ronald Fleming said that was his car.
Did you call for any help with the dog?
Yes, I need to ask for dispatch to send our animal control officer over to help get his documentation.
Did you use the key to make entry into the home?
Yes, the key that is created.
Which door did you go in? At this time, was the animal control officer present? After the dog was taken under control, did you actually go inside the home? Can you describe the layout of this home for the court, please?
Sure, it's a single story, ground level home. It has a basement. At the front of the home, there's a living room and a kitchen. On the first floor, that is towards the back, there's 2 bedrooms and a bathroom. Bedroom on the, I'll get myself confused with directions, but if you're walking through the front door, the back right is a bedroom. Then, and towards the back left is another bedroom that was arranged as an office, kind of office.
You mentioned there was a basement. Did you go in the basement as well? Where did you start going through the home when you first made entry?
I started at the side door off the driveway. I walked in and announced myself. I was at the sheriff's office. I received a response. Walked through the first floor. I made my way towards the back bedroom. Looking for the Theodora. Checked that bedroom. I didn't find anything there. The bed and some, pieces of furniture, just the walls. And then kind of went around almost like in a circle, checking the bathroom, the office. And
Did you find any people on the first floor? Did you go to the basement? What happened when you went to the basement?
checked basement. Mr. Ronald Fleming entered the house with me. And said that when I went downstairs, there would be a door to the right with a closed door that was set up as a bedroom. So I checked the rest of the basement and announced myself against the sheriff's office. I knocked on the door, didn't receive an answer. So I went to the door.
You made a reference to Mr. Ronald Fleming. Was that the defendant you were speaking with, or was that somebody else?
Danny sitting in the back of the courtroom made the 911 call for assisting the son of.
Once you were in the basement, did you find anybody?
Yes.
Who did you find in the basement? Do you see that person in the courtroom today? Can you please tell me where he's sitting in an article of clothing that he's wearing?
My left wearing jumpsuit, white sleeves.
Your Honor, may the record reflect that the witness identified this defendant.
That objection record shows so reflect.
Did you speak with the defendant? What did you say to him?
I asked him if he looked here. He said he did. I asked him if he had looked here with Theodora. He said he did. I asked him if he'd seen Theodora, where she was. He said he did. So I told him that some of the other members had called and they were all trying to figure out where she was. And I asked him to come upstairs and step outside with me so we could try to figure out where Theodora was.
Where did he go when you asked him to step outside?
Up the basement stairs to the first floor and then on the side over to the driveway. Mr. Fleming, senior firm.
Did you go back outside as well? Did you check any other areas of the property after you went back outside?
Mr. Fleming, senior at one. The yard, the inside behind the garage. And behind the house, there's a small lawn. There's a tree with a little garden around it. Side area behind the attached garage.
Did you notice anything about the yard?
Directly behind the house is kind of a small patio. Land kind of break off, and then there's a garden, shrubs in it. There's a tree in the middle. I noticed there's a wheelbarrow and a shovel sticking out of the ground next to one corner of the garden. In that particular corner of the garden, had a large patch of bare dirt.
Were you able?
Sorry.
Please go ahead.
I just said that there's nothing growing there.
At this point, had you found Theodora anywhere in the house, in the garage, or any immediately visible area of the front or backyard? After the defendant went outside, did you speak with him as well as Miss Tony Curry and the defendant's father? And who did you understand that the defendant was to Theodora? How were they related? What did he say the last time he saw her was?
He said, Mr. Fleming, I'll say Mr. Fleming Jr. If that's okay, just for junior and senior.
That's fine, or the defendant, whatever please you.
When I spoke with the defendant, I asked him the last time he saw Theodore was. At first he said, a few days ago, I asked him to try to narrow that down. Told me that gone with Theodore to a vet appointment on Monday. But last seen her maybe Tuesday or Wednesday. So trying to narrow it down a little bit further. I asked him what time of day he might have seen her last. He said he believed it was in the evening. I think we kind of settled on Tuesday. I think it was the last night.
Did you say if anyone else had been in the house?
Yes, he said nobody other than Theodore.
Did you ask him about Theodore maybe going for a walk? And what did he say about that?
Said that Theodore was kind of stooped over or a little hunchbacked, and she was elderly and she probably couldn't have fit into the driveway. She tried to walk.
After you spoke with all of these people, did you do any checks to see if Theodore had been transported to a hospital by ambulance?
Yes, I contacted dispatch and asked them to call the local hospitals, Trinity Health, or also St. Joe's and University of Michigan Hospital. I also asked our dispatch to check the ambulance service, and I also went personally checked on my in-car computer for any calls that we might have had. So get the evidence.
Any positive results?
Dispatch informed me that Theodore had not been checked in at the hospitals. HV had not been at the address or transported. We had to have any calls at that address.
When you say a very long time, what time frame are you talking about?
I want to say over a year, but I'm not 100% sure on how long that is, but more than coming in full month.
When you determined that she had not been transported to the hospital and was not at the hospital, did you do any other investigation?
Yep, I asked, I've asked Ms. Curry to call Theodore's cell phone. Ms. Curry previously told me she tried calling her and texting her and hadn't received an answer. So I asked her to call again while we were all there just to see if we could find the phone maybe.
What happened when you asked her to call the phone?
She called it, heard it right inside, the defendant went in and retrieved the phone.
Did you look at the phone? What did you notice about the status of the messages and calls on the phone?
I went through, I believe, emails, phone calls, text messages, and it seemed like all of the phone calls and text messages stopped being answered or open, read, or replied to as of this Tuesday.
Where did you put that phone?
Placed in my patrol car.
After putting the phone in your patrol car, did you speak with Ronald Fleming Sr.? Without telling me what he said, did you go back to the house again? And what were you doing when you went back to the house for that second time?
I asked the young lady to get a look around again, just to try to see if he missed anything, if there's any clues we could find that might tell us where Theodore was.
Did you ask the defendant to handle the dog at that time?
Dog was the most aggressive dog. Dog was the most friendly towards the defendant. So I asked him to secure the dog. The dog was inside of the house.
Had the animal control officer left at this point? So you asked the defendant if he could secure the dog so you could search again?
Bring the dog outside into on the driveway. There's a dog run, chain link fence. I asked him to secure the dog there so we could look around without being harassed.
Can you describe the fences that existed around the driveway area so the court can have an idea of what this was like?
Yes, if you're facing the house, the driveway's on the left. There's about a 6 or 7 foot chain link fence that touches the wall of the house, goes across the driveway, then goes back to where it connects with the detached garage. And the detached garage on the back of it is connected to the property line fence. And then if you're trying to go from the backyard to the driveway, there's about a 4 foot chain link fence that completes the dog right here on the driveway.
And that fence that's between the sort of the that goes across the driveway before you get to the door? Is there like a gate in that fence system? There's a gate.
There's also some other side things in the backyard. 4-foot section.
Did the defendant, Ms. Curry and Ronald Senior, all consent to you going back into the home? Did you find anything of significance inside the home when you went back in again?
I don't believe I found anything. I don't recall who exactly it was, but I remember Miss Curry and Mr. Fleming Senior coming and saying that they had found her Theatra's house keys and car keys. And then I believe they also brought out, it might have been the defendant that brought out her laptop and iPad.
So at this point, what of Theatra's possessions had you been able to identify as being at or near the home?
Her house keys, her car keys, her phone, I believe her ID and credit cards were in a phone case that had credit cards slots on the back, so that goes with the phone. So car, house keys, phone, ID. Laptop, iPad.
Now, at this point, where was her phone located at this time during your search?
I don't remember where exactly the phone was because only the defendant went inside to retrieve the phone when it was ringing. He brought it out to me so I could see where the house.
And you had secured it in your patrol car? So at this time, was it still in your patrol car? Did you go to get it? As you walked outside of the home, what, if anything, happened?
I was walking up to my car. I had been kind of pulling my hair out, figures of is that anything of it? I've been on a lot of welfare checks over an hour. Every welfare check I've ever been on. I was ready to call it quits. I didn't know where Theatre was. Felt like I checked every box. Everything I discovered that far told me that Theatre must be there at that house, but she wasn't there. I didn't know where she was.
Did you recall anything about your search?
As I was walking out to my patrol car, God spoke to me and told me, "Don't leave. Turn around. She's here." They suddenly had a lot of thoughts, a lot of recollections that came all of a sudden. I remember the garden in the backyard, captured freshly up tractor, shovel sticking out of the ground next to it, the little barrel. I remembered when I was how weird it was that his grandson would be in the house for however many days, 2 or 3 days. Only one there. Nobody else had come to the house. There's no signs of forced entry. Theatre was abducted. The door wasn't kicked in. The doors were all locked inside. Well, her car was there. Her phone was there. Her keys were there. Her friends who didn't live there with her were texting her phone. I saw a message her on her phone. Theatre, are you okay? She wasn't at the hospital. There's everything said if she was anywhere, she was at the house. So I thought, worst case scenario, like, what could be the answer to this? Thinking this in my head. The only person that was there with Theatre was Ronald Fleming. If she's nowhere to be found, the only place that my cop brain goes to is maybe she was killed. And if I killed somebody, where would I hide a body?
You said Ronald Fleming Sr. Did you mean Ronald Fleming Sr. was the only person?
The defendant was the only person that I also had heard of. The person who was around here. So I asked myself, if I was going to kill somebody and hide a body, where would I put it? I would bury it. And I remembered the freshly patched up turned dirt at that part. How would I dig a hole? I would use a shovel. There's a shovel sticking out of the dirt. If I'm by myself and I have to move a body, how would I do it? I would wheelbarrow and sitting out next to the patched dirt. So I walked back to the fence on the dog was out, the dog was barking at me. But to the other side, I climbed over the fence, walked into the backyard by the garden, and I saw the patch of freshly upturned dirt was there. Stepped on it with my foot. It was hard packed around the edges, like the dirt hadn't been disturbed, and in the middle it was soft, and slightly sunken in. That section that was soft and slightly sunken in was roughly, 6 feet by 2 feet. It was the size of a body, the size of a grave. So I grabbed the shovel and I started digging. I dug for a little bit. Hit something that, it wasn't a rock, it wasn't or dirt, it was something softer that the shovel struck. Kind of scraped the dirt with the shovel a little bit. Saw what looked like cloth or a piece of a sheet sticking out of the dirt. So I threw the shovel down. I got down on my hands and knees and I started digging with my hands. I grabbed the sheet and pulled it back, and I reached in with my hand. I grabbed what felt like a human limb, like an arm or a leg.
What did you do after you grabbed what felt to you like a human arm or leg?
I knew in my heart that the had been murdered, and the defendant had buried in the backyard. I sat on my hands now. I got on the radio. I called for more deputies to come to my location. I went back over the fence, went back to the front of the house, and wasn't really sure the best way how to go about it. They figured just go talk to the family and pretend like I had found it, try to buy some time for some more conversation.
Where did you go in the house when you went back inside? And what area of the home did you end up in to speak with everyone?
Immediately to the left, when you go in through the front door, there's a kitchen, like kitchenette dining.
Like an eat-in kitchen? And who all was in there?
Then Ronald Fleming Senior and his Curry.
As you were standing in there, did you talk with everybody? How long did you speak with them, if you recall?
Maybe 5 minutes.
At some point, did you decide to arrest the defendant? And did you place him in handcuffs? Did you search him and put him in the back of your patrol car? Did you question him at all? Did a sergeant arrive on scene along with many other people? And at that point, did you turn over your investigation to other members of the sheriff's department? May I have one moment, Your Honor?
Wait.
Cross-examination.
Good afternoon, Deputy. You go to this location because family called you concerned about the whereabouts of a family member. You get to the location, one of the family members there, Ronald Fleming Sr. Okay. Did you ask Ronald Fleming Sr. if he lived there? Okay. Did you ask Miss Curry if she lived there? Did you ask Mr. Fleming Sr. for identification to check his address? Did you ask Ms. Curry for identification to check her address? Ms. Curry provided you with the key. Did you ask Ms. Curry if she had authority to enter that location?
No.
Did you ask Ms. Curry if she had the authority to give you permission to enter that location? You took a screwdriver and you forced entry into one of the screen doors. So you forced entry to access the door that you could use the key. Some point you enter that location. You don't have a search warrant, correct? And you don't have permission from anybody you know to live there to enter that location. The purpose of you entering that location was to check to see on the well-being of Cedra. As a Washington County Sheriff, is there a policy on welfare checks?
Yes.
Or are you familiar with that policy?
Yes, I haven't read it in a while.
Okay.
What we're being to.
The purpose of a welfare check, would you agree with me, is to see, one, if the individual is there, and two, if they need medical assistance. You checked the home. Deidre wasn't there. Correct?
Fine.
So therefore, there was nobody to render medical assistance to.
As far as I know at the time.
Okay. And at that point, you did see Mr. Fleming, correct? You asked Mr. Fleming to come outside. That was not a order that Mr. Fleming could resist, correct?
That's the form of the question, Your Honor.
Which to what?
The form of the question, I don't. He said it was an ask, but he also said it was an order, so I'm not
Well,
clear on what the
I'm
question.
overruled on, I think it was clear enough. Go on. You can answer the question.
Oh, well, I asked that, but I don't think I doesn't to be I guess an order to say.
So it's your testimony if Mr. Fleming Jr., the defendant, would have told you, no, get out of my house, you would have just left?
Well, I think the welfare check would have probably started turning into a different investigation.
Well, yeah, I would have. So now you are no longer doing a welfare check, you're now doing a criminal investigation.
Your Honor, he said.
Sustain that.
Thank you.
Okay, what other investigation would have turned into?
All of it. Fine to be. And I believe at the time I'm talking with there's still a large area of the residents, the property that I haven't looked at yet. Probably would have gone back outside. I mean, this is speculating, telling you what I would have done afterwards. You, I guess, ask again what exactly the question.
My question to you was, Ronald Fleming Jr. would have told you, no, I don't want to leave the house, and to get out of my house, would you have left?
Speculation at this point.
Sustain.
Yeah, I don't think he'd be speculating on what his behavior would be. I could ask him what he would do under a certain circumstance.
Then I'll check.
Well, he's speculating because the premise of your question didn't happen.
Okay.
So I sustain.
When you are questioning Mr. Fleming, you have him or you ask him to leave the location, correct?
He just said, why don't you come upstairs so we can talk about how to find the theory.
Okay. But you didn't have him just go upstairs, you had him go outside.
Yes, I said upstairs and join this.
And by going outside of the location, you had Mr. Fleming Jr. go from a location in which you could not make a warrantless arrest to a location in which you could make a warrantless arrest. Correct?
Objection relevance.
Yeah, it goes to Mr. Fleming being in custody and whether or not this officer is acting under the exigent circumstances exception, or if he's doing a criminal investigation inside a home without a warrant.
I don't know that it necessarily goes there all over. I'll allow it. I know that it matter much, but go ahead.
Yes.
By having him leave the inside of the residence, you had Mr. Fleming Jr. go to a location in which you could make a warrantless arrest outside the home.
I'm not aware. I don't know how true that would be. Still be on the criminal problem at the location.
At this point, after speaking to Mr. Fleming, you now realize that Mr. Fleming is the only family member present that actually lives at this location. After speaking with Mr. Fleming, you now realize he's the only member of the family present that actually lives at that location.
Just so we can be clear, you're speaking of the defendant.
Defendant, Fleming Jr., yes, sir.
Yeah, as far as I knew at that time.
When you began to question Mr. Fleming Jr. outside the residence, was he free to leave?
He wanted to leave at that point in time. Probably could have walked away, although, other than having at that precise moment in time when he came up from the basement, I was shocked and surprised and had a strange feeling like that about the whole thing that I found sleeping in the basement, but I'm going to say that I do it at that point, so there we go.
And at this point, you are now suspicious as to the whereabouts of Deidre. You still have not seen or located her at this residence. And you haven't located anybody in the residence that needs medical assistance or emergency aid. You asked the individuals to go back into the home again, correct? How many minutes went by when you asked, by the time you asked to re-enter the home to search?
From the time that it spent and I walked outside.
Yeah, how many minutes was that?
Not entirely sure.
Did Mr. Fleming Jr. ever give you permission to grab that shovel and dig in that backyard?
No.
Did you have a search warrant to grab that shovel and dig in that backyard? No further question.
Any redirect.
No, Your Honor, thank you.
All right. Thank you, Detective. Miss Upton.
Aaron Sawyering.
All right.
This witness is excused. Is that correct?
Objection.
No, Your Honor.
All right, this witness is excused.
Thank you.
Clerk, please come forward and be sworn.
Seat, raise your right hand. Do you solemnly swear to affirm the testimony about to give me the truth, the whole truth, and nothing but the truth, so help you God?
I do.
See, state, spell your first and last name, correct?
Aaron Sawyering, AARYSOYRING.
You may inquire.
Good afternoon, sir. How are you employed?
Currently employed Washington County Sheriff's Office as a detective.
How long have you been a detective with the Washington County Sheriff's Office?
About 3 years, 3 months. Prior to that, I was assigned as a road patrol deputy for years.
Do you have any prior law enforcement experience before you were employed with the Sheriff's Office?
Of course, related, but not as an actual certified law enforcement officer.
You. Were you working on May 17th, 2024?
What?
And were you dispatched to 1315 South Warner Road in Ypsilanti Township? For what purpose were you sent to that address?
I've been notified by Captain Hanson that there was a possible homicide. So I was assisting a team of detectives with a search warrant. Specifically, was my task for that residence, the garage and surrounding property.
And was the search warrant obtained for the residence? And when you got there, what was your responsibility?
I kind of assisted Detective Roberts, who was in charge of processing the scene. So I brought the physical copy of the search warrant out there prior to the search taking place. I did have some part to play in the backyard where the scene was ultimately recovered.
What part did you have to play in that?
So we had involved, Detective Morrison had involved the Michigan State Police anthropology team. Hannah Friedlander, she had requested that we verify it was in fact human remains that were present as opposed to animal. So I unearthed a little bit more of the dirt around what appeared to be a white bag or a white cloth material. And then I used the sterile scalpel with gloved hands. I used the sterile scalpel to create a split into that fabric, then open that up, peered inside, and I saw an additional layer of fabric, which was a red and yellow quilt-like blanket. I then did the same with this layer of fabric, cut it, and peered inside, and I saw what appeared to be the fair complexion of a sea serpent.
What body part were you looking at?
It appeared to be the lower legs.
After you confirmed that there were human remains in the ground, did you contact any other members of the Sheriff's Department?
Yes, so I should say I used my right hand to reach into the fabric and did feel what appeared to be human remains that were cold to touch, and it did feel to be the shin area of the legs. After discovering this, I actually was on the phone with Detectives Morrison and Ryden at the time. But I did relay my findings to them as well as contact additional law enforcement at the sheriff's office just to keep them up to speed. They're currently conducting an interview.
Did you return any physical evidence or items from that location to the sheriff's department?
I did. I collected a cell phone that was belonged to, I believe it's Deidre Fleming, decedent in this case. This was already collected by Detective Roberts and was in the back of his patrol or his government issued vehicle, I should say. I also collected a cell phone that was on the steps on the west side of the home. So this was, if you're looking at the house from the street, this would be on the left side of the house. This was believed to be the defendant's phone. Cell phones and other electronic devices were on that search warrant, so I collected that, transported it back to the sheriff's office, and turned it over to our computer forensic detective.
After taking those items to station 1, is that correct? You went to station 1?
That's correct.
Which is located in the same building where we're at now? 2201 Hogback. Did you return to that Warner Avenue address? Did you stand by at the scene for some time?
Stood by for several hours. This was during the search by Detective Roberts as well as the Michigan State Police lab personnel that responded. I also was present for the exhumation of the body from the clandestine grave.
Did you eventually attend the autopsy a few days later?
I believe it was May 20th.
Thank you. May I have a moment, Your Honor?
Yes.
Pass witness.
Cross-examination.
Good afternoon, sir. When you went to the location, did you have a search warrant? Oh, when was that search warrant signed?
I don't know the specific time, but signed on May 17th by Judge Simpson. It was prior to any search of the property.
Okay. It was prior to you digging into the bag.
Prior to me entering the property or digging into the clandestine grave, it had already been signed.
Who was the affiant on that search warrant? Where did you get the probable cause facts for the affidavit search warrant?
So I obtained the probable cause for the search warrant reviewing on the camera footage from Deputy Rob, which to a welfare check, the 1315, believes that it was Warner Street, as well as from a phone conversation I overheard by Morrison, who was on speakerphone with Sergeant Hogan.
Okay. And so those were the only sources of information for your affidavit?
Specific affidavit. I believe that's likely.
Thank you. No further questions, y'all.
Reader.
No, Your Honor, may this witness be excused?
Yes, you may step down. Thank you, sir.
Defendant Morrison.
All right. Please come forward and be sworn.
Right. You solemnly swear the affirmative testimony you're about to give is be the truth, the whole truth, and nothing but the truth, so help you God. Have a seat. State, spell your first and last name for the record.
Detective Heather Morrison, HGA,
You may inquire.
Good afternoon, ma'am. How are you employed?
I'm a detective of the Washington County Sheriff's Office,
How long have you been employed as a detective?
since 2020.
Do you have prior law enforcement experience before you were a detective?
Yeah, I was with the town of Washington County since 2006, so 19 years.
Were you working on May the 17th, 2024? How did you become involved with an investigation into the homicide of Deidre Fleming?
Man, doesn't say here, it's believed that great. And everything they're doing.
And did you respond to the scene or do something else?
Initially spoke with MSP, let them know, that's when we got the information from Detective Chartering, we FaceTime. Well, first we reviewed the Detective Rob's body camera and got the information, got the search warrant signed. Then we found that the contact was coming back to station 1 to be interviewed. So we had MSP en route, got the body discovered by Detective Chartering, and then I interviewed the suspect.
Where was the defendant interviewed?
In interview room number 3 at the sheriff's office here.
Are you able to identify the person that you interviewed on May the 17th, 2024? You see him in this courtroom? Can you tell me where he's sitting and what he's wearing?
People green jumpsuit on and your shirt.
Your Honor, may this record reflect the witness identified the defendant?
So reflect without objection.
Was the defendant read his Miranda warnings?
Yes.
Did he waive those rights and agree to speak with you and Detective Reisanen? Did he say how long he'd been living with Deidre?
Approximately 2 months, about 2 months in time.
2 months this time, you said? How did he describe her physical condition?
He said that his grandmother was frail, that she had rods in her back and neck, and that she had COPD. That she would not be able to make it to the end of the driveway if she had to walk.
When asked about Deidre was, what did the defendant say at first?
That he didn't know.
Did he say when the last time he saw her was?
He said that he believed it was Tuesday morning.
Was the defendant questioned about any digging or other activity that had happened in the backyard?
He was.
And how many people did the defendant say had dug in that backyard?
He said the only people that have access to the backyard today were, to his knowledge, himself and maybe Deidre did a little bit.
Had anyone else been in the backyard digging to the defendant's knowledge?
Yes.
Was the defendant ever confronted with information about what had been found by law enforcement in the backyard garden / flower bed area? How was that done?
The material that had been exposed, photographs that we received from the scene.
At first, did he claim any knowledge of what had been found in the garden or flower bed?
No.
What did he say?
So that he didn't know what it was.
Eventually, did you discuss what was found in the flower bed? You and Detective Reisman with him?
Yes. He found, Deidre.
What did he say after that happened?
That he knew what happened, but he was afraid that we wouldn't believe what he had to say.
Did he ever tell you how Theodore had gotten into the flower bed?
Yes.
What did he say?
So that he picked her up and that he drugged her out there after he had killed her.
Did he describe killing her?
Yes.
What did he say about that?
You said that on Tuesday morning, his grandmother had come downstairs. I guess I should back up and say that earlier, Monday, they had gotten into a little bit of an argument about what happened at the vet. She also had been talking to him about getting a job or going back to school. This made him feel like his grandmother didn't love him anymore. He had felt that way for a while.
You said the vet. Let's stop there for a second and back. You said something about Monday at the vet. What happened Monday? What did the defendant say happened Monday at the vet?
Monday at the vet, he said that Deidre got upset with him because he was laughing. The dog was this big dog. He's uncontrollable.
And they had gone to the vet with the dog?
Yeah.
What happened while they were at the vet?
So the defendant had a whole Humphrey, who's the dog, had a whole Humphrey, and because he wasn't sedated properly. And so Deidre got upset, and Ronald ended up storming out by leaving Deidre there.
What did he say happened later on Monday?
They had a conversation about him getting a job and going back to school.
And anything else that happened that day that he said between the two of them? What about Tuesday? Anything that he said happened between the two of them on Tuesday?
Tuesday, Deidre came downstairs, asked him about getting a job or going back to school again. He said that Deidre had a knife in her hand, and that he came out of his bedroom. She was standing in the threshold to the door, kind of just with her hands. The way that he did it in the interview was just kind of like her hands on her hips, as the grandmother would.
You've just made a motion with your arms that I want to describe and make sure is accurate. You've sort of closed your hands and placed the tops of your hands on your hips with your elbows out at an angle. Is that correct? Does that describe the way that he said Theodore was holding her arms?
That's how he displayed it, and then
Very good. What did he say happened after that?
he said that he came out and that they continued their quote unquote.
What happened next?
He says that Deidre lunged at him. He grabbed her, spun her around, disarmed her.
When you say disarmed her, what do you mean?
So he did a reenactment with Detective Bryson, and he said that he knocked the knife out of her hand.
What did he say he did after he knocked the knife out of her hand?
He put her in what I would call a very naked choke. So he demonstrated putting his arm around Deidre's neck. And that she was able to escape from that. Then she turned towards him and tried to claw at his face. So he grabbed Deidre around the throat, one of his hands, and strangled her from the top of her neck.
Did you ask him if he had been hurt during this at all?
Yeah.
What did he say?
He said that he had some scratches on his left arm. He also gave alternative explanation for it, that either being the dog had scratched him on Monday. He at one point said maybe the knife, that he recanted that was the knife that either the dog or teacher had scratched on their hands.
You described a few moments ago that he had put her in what you called a rear naked chokehold. Could you describe exactly the positioning of their two bodies that he said that they had while he strangled her with his arm?
So a rear naked choke for me would be his arm was below her neck, coming around, cutting off the airway, or the neck. Her back would be against his chest, so she would be facing away from him and he would be directly behind.
What did he say happened after Theodore? Well, he said he strangled her until he felt her neck snap. What happened? What did he say happened after that?
He drove her body to the back of the basement, where there was maybe a storage or wine cellar area, which kind of like a big area with shelves. He laid her against the wall. And then later he put her on top of a quilt in that area. He waited till it got dark, and then he carried her up the stairs. His explanation for that was that she was heavy. He went outside, and in the area where the garden had been previously dug up for some hostas, or other plants. He just left her laying there on the ground and then dug the hole so that it was big enough for teachers to fit in. And then
May I have a moment, Your Honor? I'll pass the witness.
Cross examination. Good afternoon, ma'am.
Good.
How long you been a detective?
21.
So you've been trained on taking statements from suspects in custody? One of those things you've been trained on is when a suspect's in custody, before they can be interrogated, they must give a waiver of their Miranda rights. And that waiver, you've been trained, has to be voluntary.
Yeah.
And the individual has to understand the rights that they are waiving.
Yes.
Is your testimony before this court today that when you saw Mr. Fleming Jr., the defendant, were you able to observe him?
Yeah.
You were able to observe his mannerisms?
Yeah.
You were able to observe his speech? And you believe that he was of competent mind to waive his Miranda warnings?
Objections to that.
Sustained. Sustained. As to the phrasing of the question. Go ahead.
Did you believe that he understood his Miranda warnings? You didn't see anything to alert you that he may have some sort of a mental illness or mental situation prohibiting him understanding those Miranda warnings?
Fleming stated that he had some college education, that he had not been drinking, And that he had stopped smoking marijuana so that he could gain employment.
And at this time, I'd ask the court to take judicial notice that Mr. Fleming Jr. has been found incompetent. It was at the forensic center, I believe, according to the court file, for close to a year.
Your Honor, he said that restored to competency.
That he's since been restored,
He's since been restored to, absolutely.
but you're asking me to take judicial notice of the competency. Time frame?
Yes, Your Honor. One of the things.
But you're not asking me, because I couldn't, to make a finding regardless of that as to his competency on the date and time that he's questioned.
No, but you couldn't do that, but we'll be asking you to take that into consideration in evaluating the statement. The court can, when evaluating the statement of defendant, consider circumstances surrounding this. One of those circumstances would be his mental state.
Yes, but you're asking me to, I think, take his competency as a way of indicating that I would be basically adjudicating his competency on the date and time that he's questioned, based upon what was a finding that happened later.
Yes, Your
I
Honor.
don't think I could do that.
If that's court's ruling, yeah, we accept that.
Okay.
Yep. No further questions, John.
Any redirect?
I have a redirect, Your Honor.
You may step down. Thank you. Additional witnesses.
No additional witnesses, Your Honor, expressed.
No witnesses. All right.
Your Honor, people do request the court bind over the defendant on the sole count of open murder for the death of Pedro Fleming. I do believe that we have established by a probable cause standard that the defendant did cause her death. And I ask the court bind this matter over for further proceedings. I'll reserve any further argument for rebuttal.
Trust.
Yeah, we'd ask the court to not bind over again. We rely on two reasons. We believe here the warrantless entry into the home of Mr. Fleming Jr. can only be justified under the emergency aid exception. Now, the emergency aid exception allows police to make a warrantless entry into a dwelling in which they reasonably believe, based on specific articulable facts, that some person within that dwelling is in the immediate need of aid. They are not allowed to do anything more than that is necessary to render aid to a person who may need aid. Here, the responding officer, based on the testimony here, we would concede that the initial entry into the home was under an emergency aid exception. He received information from family members saying that they hadn't heard from a family member for quite some time, that was unusual for that family member, which is important. The court has to determine whether or not it was unusual for this family member to not be in contact with other family members for days in order for the court to render this emergency aid exception valid. And then the officer goes in and does a check to see if there's anybody in the home that needs aid. There is not. At that point, the officer has done everything that is necessary to determine if there's somebody in that home that needs emergency aid. Now this is a criminal investigation. He is suspicious about the whereabouts of the individual who's missing, Thedra, and he is investigating that. As part of that investigation, he goes to a backyard. He starts digging. He does not have consent of anybody that has standing or authority to grant consent to dig in that backyard. He digs in that backyard without a warrant. He makes a discovery of the body. That information is passed along to a detective who ultimately gets a warrant, but based on the questioning of that deputy, the substantial majority of the information that came from or that went into the affidavit came from the people who were at the scene and would have come from the unlawful digging and warrantless digging into the backyard. So any argument that inevitable discovery would apply to the discovery of the body, I don't think can stand. Your Honor, we'd ask the court to suppress the discovery of the body in this case because the officer clearly acted outside the exigent circumstances exception when he started digging in the backyard. There is no reasonable argument anybody can make that the officer thought that somebody needed emergency assistance when he started digging into that backyard. And the courts have been clear, there is no homicide exception that applies to the exigent circumstances or warrantless search exception. Secondly, Your Honor, we'd ask the court to not give any credibility to the statement given by Mr. Fleming Jr. To the detective. I think the court can looking at the circumstances surrounding the giving of that statement, that my client was not in a position in which to credibly make a decision to speak to police and waive his Miranda rights, Your Honor. Thank you.
Thank you, Your Honor. I will start by acknowledging that I think defense counsel's asked for suppression of evidence based on the lack of a warrant for the initial discovery of Theodra's body. The question before the court, I know the court knows, is of course bind over on the homicide. So I don't know that I understand defense counsel's request and his argument, but I do believe that the suppression issue will be fully litigated in circuit court.
Yeah, but that doesn't mean that the defense can't raise it at some point, because if I were to agree with the defendant, then there may not be probable cause to find the defendant. Oh,
Yes, Your Honor.
yes, sir.
And we appreciate it coming up, and I anticipated this issue coming up at this level as well as when we get into circuit court. I will say that there is more than one exception that applies and that people would allege apply. First of all, consent. The first initial search of the home when we talk about our consent exception is done with somebody that appears to have authority. Your sister has a key to your house and she hasn't heard from you. She can give consent to a police officer to go in as a community caretaker, as agent of yourself, to look for this person. So I do believe that the search with the initial house would be fine for consent, as well as the secondary search. When the defendant, Ms. Tony Curry and Mr. Ronald Sr. are all asked if he can look again, and the defendant, in fact, locks the dog up in the run and goes ahead and looks. Also, Your Honor, I think that it is important to consider the exigency of the situation. This is an elderly woman. No one's heard from her in days. Her phone is full of missed calls, full of unanswered text messages, emails, all these sorts of things that the detective Rob did indicate to the court. So I think it's important for the court to consider that there is an exigency element here. We don't know where Theodra is. We're looking for Theodra. At the time that he's speaking with Detective Rob, at that time, the defendant is the only person in the home. He hasn't seen Theodra. He doesn't know anything. He doesn't know where she is. He hasn't heard from her. And it's concerning. We are not sure where Theodra is. I do believe that we have sustained our burden. I think that we do have at least more than one exception to the warrant requirement that would apply here. And inevitable discovery is one of them. Theodra would have continued to be missing. There would have continued likely to be more investigation, more police contact, more police involvement in this case. So I do ask that the court bind this case over and allow us to proceed to trial in the circuit court.
Yes, sir. If the prosecution wants to argue community caretaking actually has a higher burden than exigent circumstance. Exigent circumstance is reasonable belief. Community caretaking is probable cause. And for community caretaking, they have to show that these officers believe that there was an ongoing emergency and a danger to the public. There is clearly no testimony that they believe to that. And the deputy testified he did not ask for consent before he started digging. So there could be no consent to that portion. We conceded in our
would consent to access to the premises have to be to every act?
Yes, the officer has the operate.
What I'm asking is, if you give me consent to go into the house, I don't have to get separate consent to enter the kitchen as opposed to entering the bedroom. Right?
That is correct, Your Honor. And now consent, now he's now dead, not on the court anymore. Now I didn't agree with a lot that Justice Andrew Scalia said, but he was not a fan of consent.
Yeah.
I actually am.
That Mr. Johnson is going to quote Scalia. Go ahead, sir.
And the aspect that he was not a fan of consent because he didn't really believe that suspects could ever really consent to armed police officers. But he and the courts have always kept consent and made it very narrow and tight. that an officer has to have consent for the specific actions that they're engaging in. I agree with you. If an officer asks me to search my home, that includes the bedroom and the kitchen, because I can revoke the consent at any time. But if an officer asks me to search my home, and then the officer then goes into the backyard and starts digging up, engaging in action that he has not asked for permission to do, then that would be outside the scope of consent.
Yeah, but hold on, that's not what happened here though. Because the officer never leaves. The officer is, it's not as though the officer was in the house, got consent to do something in the house, then walked outside and just went to the backyard. They had already been through the backyard, had gone through. So this was, where are you saying, if this court believes that there was consent, not only to search the house, but also to search the premises, where are you saying that consent ended?
It is
where they needed additional.
Yes. I concede there was consent to search the house. There was never any testimony of consent to search the yard or the structure that was in the yard. It is our position that the deputy needed additional consent.
Why would he have needed additional consent? Because when they're in the home, they all leave the premises and start walking around the outside of the premises into the yard, right? So you're saying that once he's in, then they come out, that he has to have some separate consent?
To dig in the backyard?
Well, no, because once he's there, the digging would be like searching the house and moving a board, and all of a sudden you see something. The issue of consent, I'm trying to figure out where you're saying he needed additional consent.
He needed additional consent to search the yard. He had permission to search the home. He did not have permission to search the yard. And it's our position that the deputy knew it. That's why he didn't ask. He just went back there and started digging. He didn't even ask for permission to search the yard. And we believe.
But if the deputy believed he already had consent, of course, he wouldn't ask again necessarily, right?
Well, he didn't testify that he believed that he already had consent. So, I mean, that I guess that's something the court will have.
Well, the actions of what happening are continuation. If one believes that consent was originally given, that he's walking around with the individuals that are giving him that consent. I mean, he's given a key, go into the premises. The three of them are there. The three other individuals
are in the house, yes.
In the house, but ultimately they're all outside, right? And then there is this searching around the premise.
Right, they're not all outside at the time of digging. They're, based on the testimony, and it is our position, the only person that had authority to grant consent was Mr. Fleming Jr. We do not believe that there's facts in the record that would establish by probable cause that this officer could have believed that anybody else had the apparent authority to grant him consent after the moment he discovered that Mr. Fleming, the person.
Wouldn't I believe that a person who hands me the key to the premises has the apparent authority to give me consent to search? Why wouldn't I believe that? Why wouldn't that be a reasonable belief?
Your Honor, people give keys to neighbors or family members for, all kind of emergency reasons. That doesn't mean that they can.
But that, as to whether or not that person, there's a difference between whether or not that person exceeded their authority and whether or not the person who is sort of believes they have consent reasonably believes under the circumstances that this person can grant consent for me to search.
And Your Honor, I think we are, we getting off. We're in separate lanes. We've conceded.
Oh no, I know we're in separate lanes.
We've conceded the initial entry into the house was based upon the apparent authority of a woman that was there. Okay. Once the deputy discovered that the only person that lived there was Ronald Fleming, then the apparent authority of anybody else there has now been dissipated. There's only one person who would have standing to grant a search under those circumstances. Now, we can get into.
I'd like to
Olson
case law on that because I don't think that's true.
Minnesota v. Olson.
The deputy comes into the home. He's searching. I find somebody there. Somebody says they live there. You're saying at that point, the consent terminates?
Yeah, what I'm saying is the apparent authority terminates. Remember the testimony. The officer didn't ask these individuals any questions to ascertain whether or not they had any legal standing in that location. The only person, based on the testimony, that had legal standing in that location was Ronald Fleming Jr. Surely under Minnesota v. Olson, I don't think there's any argument the government could make and that the court could accept that Ronald Fleming Sr. or this other woman had standing at that location. So now we're looking at who had the apparent authority to grant the second consent search.
But why was the second one needed?
Because the search had terminated, the first search had terminated. Yes.
They hadn't left the premise. I mean, where are you saying it terminated?
When the deputy does not find Deidre, comes back out with Mr. Fleming Jr., and he's given that testimony about him being outside for some period of time, talking with the family, before he asks again if he can go search. It is our position that that second entry was not an exigent circumstances search. It wasn't even a community caretaking search. It was simply a consent search. She was not there. There was no reason for him to believe that she was inside that home and needed aid. But he had consent to search the home, which at that point was given. We are not contesting that. The issue here is the scope of that search. The scope of that search did not exceed to the backyard.
But the problem is that problem with that analysis is the individuals, it's the officers acting, the individuals who have granted him the consent as they're going around are the same individuals that are going around the backyard with him. That's the problem or the trouble I guess I'm having with your argument. It's not as though he had never gone into the backyard prior to that. That's not what happened here. That initial search, you'd have to show me something that initial search, that consent that the officer was acting under only included the physical structure of the house and didn't include the outside, because the factual circumstance of this clearly in my mind indicate there was also this consent to search the entirety of that premise.
Now, with that concept, it is our position that the courts of higher jurisdiction have taken a separate position that the court has taken. It is the position of the government to show that the consent was valid, what the scope of the consent was, and that the officers acted within that scope. It is not my burden to establish in a warrantless search that the government acted outside the scope.
No, but I understand that part of the argument, but you're saying that at some point it ended or didn't include the outside of the premises.
Exactly.
And I'm asking you, when did that happen? I'm stating what the facts are as I see them, and that is that there was the inside, there's the outside, they're all going around the premises. At no point did that search stop.
Well, I guess that makes it easier for me. So under the case law, the court has to ask itself three questions. Did the officer ask anybody with standing to grant permission to search that backyard? The answer to that question is no. Did the officer have a search warrant to search that backyard? The answer to that question is no. And so now is that the consent is ambiguous, or there's an ambiguity in the consent of who has the burden of showing that the officer's actions were within the scope of that consent, and that is the government. And here,
you're saying that when they first come to the house, Someone hands him a key, the officer goes in, that even apparent authority to the apparent authority that person exhibits granting consent at some point just disappears?
Absolutely. My sister has a key to my house. She hasn't heard from me or my.
Both can be true, Mr. Johnson. One can have apparent authority grant that consent, but also there be another person that can grant consent. It doesn't make the other, it doesn't negate the other. Both can be true at the same time. Can't they?
I don't think so, Your Honor. My sister has a key to my house. She calls the police and says, I haven't heard from whomever that lives at this residence. I'm giving you permission to enter. The police enter the location. They see me there. I live there. At this point, no reasonable officer could think that my sister, who doesn't live there, has the apparent authority to continue to grant searches at that location when an individual who lives at that location is actually present.
Okay. But but isn't that dependent upon what one's searching for?
No, Your Honor, the emergency aid exceptions made that clear. The heightened or crime that is suspected or the type of emergency that is suspected has no bearing because the courts of higher jurisdiction have always been clear. Go get a search warrant. There is no reason why this officer could not have radioed in and said, hey, been called out here for a welfare check, not find anybody. These are my levels of suspicion. Need a search warrant to search the entire premises.
Okay.
Thank you.
Two final things, if I may, Your Honor. The
Yes.
court has received the post-mortem examination report. It does indicate that the cause of death was strangulation, the manner of death was homicide for Miss Deidre Fleming. And the last I'll say is that defense counsel's example about giving his sister a key, his sister calling in a welfare check, and then the police arriving at his home and seeing him is very different than what happened here. Because the subject of the welfare check was Deidre, not the defendant. Thank you. Nothing further.
All right, Chris, gonna take a brief recess and I'll come back to you.
Maybe see.
Record in City of Conneaut versus Theodore Nikoloff, case number 25 CRB 236. Mr. Nikoloff, just going over some brief history. Mr. Nikoloff was found guilty of one count of sexual imposition, a third-degree misdemeanor, after a jury trial. That jury verdict was rendered on January 30th of 2026. The court deferred sentencing, and while that sentencing hearing had been scheduled and was, we were waiting to conduct that hearing, the defendant, through counsel, filed on February 12th of 2026 a motion for a new trial, as well as a motion to supplement and a request for a hearing. The court did set a briefing schedule, and I know that it took some time for the transcript of the jury trial to be completed by the court reporter, because that's what the defendant wanted and needed to supplement the motion. Mr. Lewis, on behalf of the City of Conneaut, filed the next day a response in opposition to the defendant's motion for new trial. It was on March 23rd, 2026, that the defendant filed a supplement and citation of authorities to the motion for new trial. And then the City of Conneaut, Mr. Lewis, on behalf of the City of Conneaut, filed a response in opposition to that defendant's motion to supplement and citation of authorities to motion for new trial. This case is set for a hearing today on the motion for a new trial. Mr. Nikoloff is present. He's accompanied by his attorney, William Bobalski. Also present is Law Director John Lewis. So I'm just going to take argument on the motion. I'm not going to make a decision today in open court. I'm just going to take argument today, and then I'll issue a written decision. So it's your motion, Mr. Bobalski.
Your Honor, are you in agreement with waiting?
Yes, no, Judge.
Your Honor, if the court pleases, and I realize I asked for the hearing, but the briefs are before the court. I doubt that we are going to give the court much other than what are in the briefs now that the transcript has been filed, as it had been before we filed the briefs. Right around the 11th of March.
I have not received the transcript.
It was a full transcript. I wonder if your court reporter handed it to me at some point in time.
Yeah, I mean, the court has not received a copy of the transcript. I only received your motion with this.
I thought it was kept here. I will bring it back.
Yeah.
Today.
Okay.
And if I may interject, I did receive a copy through email, I believe.
Okay.
It was emailed to me. I don't remember if it was from the court reporter. I think it was.
I think it was emailed to everybody, and all that I got was the files and copies, and I'll bring it back.
Well, we'll have to check with the court reporter, but I didn't get a copy. Yeah, I think I will.
No, I can, it's a box, so that's why.
Yeah. Okay.
I'm glad we learned, because I think it's part of the record.
Right. So, I mean, while we're here, so in reading what I read, especially Mr. Lewis's response, you know, I guess what specifically, I mean, what is specifically the focus of the defendant's argument here that the verdict is contrary to law, or that there was some error that occurred? So is it allowing the text messages into evidence? Is that the sole focus?
the question, there had been earlier a motion in limine saying that witnesses that are going to talk about having interviewed the complainant were going to testify as to what the complainant told them. So that's hearsay, that should not come in. That was the first focus. The second focus was the text messages. This was a case that, it's extremely difficult to pinpoint what, other than the totality, I guess would be a question about what the jury believed or didn't believe. We can't say exactly, but we know that the text messages came into evidence. They were testified to, and that, because of the fact that there's only the testimony of the two participants to the text messages. One is, I don't consider that adequate authentication. And if I may, there were two dates on the text messages, each of which were either middle of the night or early morning. And there's no question when the event, and that was on the date of the issue that came about from the complainant's visit and boarding of my client's boat. There was zero mechanical input as to dates and times of the text messages, except 4 a.m. and 9 a.m. All of the other messages are issues that we're speculating as to what time. There was no cell phone bill that was brought in to say who received and made when, and there was nothing printed on the, what I think were photographs of the text messages from one of the phones in the exchange of text messages. That was a very important one. There's case law on text messages.
I know, and this is what I don't understand. Because on January 29th, I issued an order and I took time because I had a feeling.
Yeah, may be seated. You got all set open.
Yes, I got it. Thank you.
Not a problem. They didn't want you to be. I was looking out for you. Need you to know that. Court does call the case, recall the case of the people of the state of Michigan versus Ronald Fleming.
Ashley Lonnie Feltus for the people.
Good afternoon, may it please the court, Kareem Johnson, on behalf of Mr. Fleming.
The court has heard the testimony and argument of counsel regarding the preliminary examination in this case. The issue, and it have to be dealt with, certainly upset the court for the purposes of the search. However, court, in looking at case law and also just the factual circumstances, they're a little bit different than anything the court was able to find. But what is very clear is that when the first deputy arrived, that there was given to that deputy consent to search the premises. There's no doubt in this court's mind that there was, and that whether or not that person granting that consent, either one of the two that originally are, I think it was reasonable that the officer were to believe that they had apparent authority to grant permission for the search of the premises. The question then becomes, and I think it's also important, and Mr. Johnson has brought up on behalf of the defendant, the issue of standing to challenge the search. And then their standing is different from that apparent authority or grant of consent. Standing would come into play if there were a challenge to the search. And does somebody have standing to raise that challenge? That really is the customary way that that would work. And I don't think that this really would involve an issue of standing, but certainly as to whether or not there was proper consent and whether or not the officer acted certainly in good faith in terms of that consent. I think it's also important to point out, as the court has, that consent, at no point do I see that the officers acted beyond the scope of the consent that was granted. Just on the face of it, they went into the house, but then came out of the house and at some point re-entered the house, but they were searching the house and the adjoining area. There was a walk around in terms of the backyard because the freshly dug portion of the garden area where the decedent was found was indeed noticed by the officer at a certain point. He doesn't do anything with it at that point, but is still going around. And if the court, in terms of the court's notes, it is correct, there's other information being given to the officers that are there. For example, that we can't find a decedent. We've done all the calling around to hospitals, ambulance, seeing if there are calls for service. There aren't any. But then at some point, they're given her house keys, car keys. Her phone is obviously there. There are, her vehicle is there, and she's not anywhere that they can see. And certainly at that point, one can look at it in a lot of ways. Either I think under a certain theory, they're operating on that consent, but I think also those items are creating certain extended circumstances for these officers to continue doing what they're doing because we cannot locate this individual. But what appear to be all of their personal effects are there. They're at the house. So something certainly is amiss, and it involves an elderly human being, and they go through that process. So from this court's perspective, I don't think there's an issue, certainly regarding the consent to search and the initial search that was done. Had Detective Rob or Deputy Rob at that point, upon discovering what he discovered, continued doing something, then maybe we get into another issue of whether or not there should have been a warrant for him to continue on. But I don't think his intrusion and the, say, minor digging, but is looking to uncover what this was in front of him in search for this individual that they can't find is beyond what would have been the consent that was granted. Would also know the three people there, those that court believes certainly had apparent authority to grant, from the officer's perspective, to grant consent, as well as the person that defendant claims had the actual ability then, which I don't entirely agree with, but I understand the point. While his deputies doing all of this, no one is objecting at all, which I think is further indicia of the consent that was granted to the officer to act. And so for those reasons, I don't find that the issue of the consent, it was followed up with the warrant with reference to the charges of the open murder outside of the confession of the defendant as to what they did and how they killed the decedent in this case. there is also ample evidence where he's in this sort of curtained out dark house in the basement where the owner of that premises hasn't been seen for 3 or 4 days. He does nothing, does not act, does, at least apparently based upon this record, does nothing to this court indicates not only that he intended to kill the defendant or kill the decedent and did so, but also intended in some way based upon his actions of taking the body, burying it. In doing that, he was covering up his criminal activity. So taking all of that into account, and just one other thing, I do not find that there's anything defective in the Miranda warnings given, and who it was, the Detective Morrison testified that she believed that upon giving of those warnings that the defendant understood those warnings, and that the assessment that she made is that he voluntarily waived those rights, and that he did answer. So taking all of that into consideration, taking all of the evidence, including People's Exhibit 1, into evidence, the court does believe that the people have indeed sustained their burden in this case, and would find the defendant over on the charge of overload. Johnson, you acknowledge receipt of the information waiver treaty?
Yes, Your Honor, I do.
All right. Your client is standing mute to the charges.
Yes, sir.
Been in every way, form, or reading, standing mute. Court will enter a not guilty plea. Pre-trial in this matter will be set
May 26th at 1:30 with Judge Conkey.
May 26, 2026, 1:30 before Judge Conkey.
Thank you. May I present
Thank you.
anybody?
Yes, bond, Nyla bond will continue. Just need to top the bag. All righty.